Yes.
It is lost. I have filed a bail application, my lord. Can it be on 26, my lord? The only ground is that, my lord, on 26, my lord, the connected case is fixed for diary.
Okay.
I'm okay.
NPCD bail it was last listed your lordship on 20 Friday, but not listed. So my prayer it may come out tomorrow, my lord. Otherwise it was well, there are two things.
Okay.
Maybe listen, I am praying for listing one bail application. Two more of it.
No.
Yes, Heinous on Article 21.
26th.
May I please, your lordship, I would like to mention item 13.
Hmm?
1-3.
1-3. Yes.
Kindly examine this matter and fix this matter on tomorrow after 1.
Item number
Item number 1 to 13.
30 on the prayer of the Learned Council. Let the matter be listed. Let the matter be listed March 5th March. 5th of March.
Highly obliged.
Item number 4,
Hmm.
some personal program is maybe after 2 weeks.
The prayer of the Learned Council. Let the matter be fixed after 2 weeks.
May it please your lordship, I beg to mention item number 1, kindly pass over it for a week.
Hmm?
Item number 9, lordship.
9.
Yes,
Passed over for
a week.
a week.
Yes, sir.
Item number 1 on the prayer of the Learned Council. Pass over for a week.
May I please, your lordship. Proceed. I beg to mention item number 23, lordship. Also, the CD not received. 23.
23, right? CD not received. Let the matter be listed on 6th of March. 6th of March.
May I please, your lordship? I beg to mention item number 16, my lord.
Item number
16.
16, yes.
TCR has been received, my lord, but there is a cross case. CD is not received. It was called for.
CD was called for.
CD was called for.
Okay, CD not received. Let the matter be
16.
listed on 9th of March.
Hmm?
9th.
Some earlier date.
9th, not before this.
May I please, your lordship?
6, my lord.
9th. Lot of
May-
matters have been fixed on 6th. Lot of matters have been fixed. It won't be possible, 9th.
May I please, your lordship? I beg to mention for listing the NDCPT bail application, sir. Number 26.
No. 5th of March. 5th of March or 2nd of March. 2nd of March.
Motion.
2nd of March. Not before that.
With the consent of the other side, I beg to mention item number 3, my lord.
Hmm.
Can it come in the second week of March?
Okay, Mr. S. Das, the Learned Council, preparing for the respondent. We respondent with the consent of the other side. Raise it for the matter to be listed on
Second week of March, madam.
2nd week of March. Let the matter be listed on 12th. 12th.
Last week of March.
No, it can't go till for this March. Okay, they will fix it on 20th of March.
My lord.
There is a interim order.
Interim order so past under.
Highly.
May I please your lordship, I beg to mention item number 24. Lordship, the matter may be listed after a week as my senior is unwell.
24.
Yes, your
Okay,
lordship.
on the prayer of the Learned Council, going for the accused applicant, let the matter be fixed after 2 weeks.
Right.
My lord, there is a small prayer with regard to item number 16. Issue may be, reminder may be issued, my lord, for CD.
CD, he is there. No? CD.
In the cross case, my lord.
Call for the CD is already there in the order. It will come. He is there. Learned APP is there.
May please, your lordship. So regarding item number 22, perhaps case diary is not available.
CD not received. Let the matter be listed. When?
There's an interim order, madam.
6th of no, 6th will be too much. 10th of March. 10th of March.
Similar prayer for item number 33.
Interim order passed under continue. Item number
33, madam.
same order for 33.
I'm deeply aware.
Yes, yes, fast.
May I appear? So I beg to mention here item number 21 of today's list, Lordship.
Hmm.
Here probably case diary have received, Lordship. And only I'm praying, Lordship, it's sorted because Lordship, one of the petitioner is a lady and she is lodged in jail along with 8-month-old baby, Lordship.
Not before first week of March,
Lordship,
first week of March.
Lordship. On 5th,
On
Lordship.
the prayer of so and so, with the letter matter fixed on fifth of March.
Item 20 already mentioned, Lordship, the interim is there, that will continue.
Item always say, item number 20, interim order supposed to will continue.
Lordship, I beg to mention item number 28.
Hmm.
CD not visible.
She did not receive. 20, item number 20, she did not receive, letter matter fixed on
Lordship, I am on interview.
28. 20.
28.
28. Mr. Doctor is there. Okay, let it be listed on, she did not receive, let it be listed on 10th of March.
Nice.
Item 22, 33, which was mentioned, madam. Here, interim order.
No, interim.
Promotion BA, item number 1.
Kgs of ganja money.
Hmm?
6.8 kgs of ganja. So Lordship, in the FIR page 14, man. Lordship got it. From the third paragraph,
It's from your position.
not exactly from my position, 440 grams. And from one common bathroom, my lord, the other. Lordship.
So we'll call for the signal.
That's why another matter is fixed on 27, my lord. Out
Same,
of the
same
47.
FIR.
Look, it's AB 237-26,
When?
27 to AB 237. From pneumatic,
27th.
27.
Okay, I heard Mr. So and so. Which was it? And non-DPP also. There is an application on this also. The case relates to recovery of ganja. 440 grams of ganja from the dicky of the scooty driven by the case applicant. Also, call for the CD. It is submitted that bail application arising out of the same FIR. That is bail application number,
AB number 237.
AB number, na? Anticipated bail application, anticipated bail application. Number so and so
237-26.
is listed, it is being listed on, is to be listed on 27 March,
27-2, my lord. 27.
sorry, 27/2, sorry, 27/2. Let the instant case also be listed from 27/2 along with the aforesaid bail application.
Item 2.
It call for a civil hearing. Yes,
The application, Lordship. He was arrested on 31/26 is the principal of disseminate.
31,
31/26, 30th January.
okay,
FIR Lordship, page 30. Basically, allegation is that he has touched the body of the student. That is the allegation.
we will call for the civil. Notice has to go,
Notice has come.
okay, these
So
are.
we will serve the notice.
I heard Mr. The talented by council for the accused applicant. Then right Arjay Burwa, PV. This is an application under so and so. The case relates to sexual assault. He is the principal.
He is the principal of this.
Case relates to sexual assault by the principal of Mr. Modified Secondary School. School on. Who is the victim?
Victim is a student.
On a student of the college, of the school, huh? Let notice be issued on respondent number 2 through the office of the, through the registry as per the notification, prevailing notification issued by Gauhati High Court. Notice to respondent number 1 is dispensed with as non-ATP center's appearance. Call for a CD. There's a call for a CD, later matter fixed on
It will be on 6th of March.
5th of March. 5th of March.
Item number 6, bail hearing BA.
Wait for something.
Let it be at 2 o'clock.
Hmm?
Let it be at 2 o'clock.
2 o'clock. Somebody's coming. What? You're there? You're there in the case? Huh?
May I please, your lordship, my senior is on legs, can me the matter may pass over for timing, lordship.
Okay, we'll tell him that we'll take it up after 2.
After
After 2 o'clock.
2,
Hmm?
much obliged.
He's Mr. Chaudhary is asking for 2 o'clock. Okay, he has some other matters.
Okay, lordship.
So we'll take it up after 2.
7,
You filed in one some additional affidavit.
Yes, Lordship.
Additional affidavit for what?
Lordship,
Additional
for
affidavit.
bringing, Lordship, from 28, page number 28 to 32.
28. $28.
Page number 28 to 34.
The additional affidavit is not there on record. 1 second, 1 second. No, it is not on record. Additional affidavit is not on record.
You give it that, Lordship. That's Lordship.
The direct record 9. This is my additional affidavit.
Lordship,
You have received a copy, Mr. You all have received. Copies. We'll send it to you. Huh?
Lordship may want to see.
It's not on record. When did you file it? Huh?
yesterday.
Then you should look into the record now whether it is there or not. It's not on record. We'll post it for some other time. Later matter, I mean, we write the learned, Mr. D. Ullah, the learned counsel, according to his applicant submits that he has filed an additional affidavit in the instant matter. Yesterday, that is,
2nd of March. Lordship.
that is 23rd. It is on 23rd.
of March.
However, the same is not available on the court. Later matter is fixed on 6th of March.
Like,
number 8,
May I please, your lordship. Lordship, the matter pertains to recovery of 242 number of FICN, lordship. Take Indian currency note, lordship. Lordship, 90 days offense, lordship, as of today, 78 days, the petitioner has been behind the bar. Case hearing was called for.
Details come.
Case that he received, my lord, it is recovered from his position, my lord, and he came from Bihar to purchase those, my lord, FICN. my lord. Now it is pending to collect the FSL report, my lord, only regarding, my lord, whether the notes are take or not.
My prayer is only considering the length of detention, Lordship. Any stringent condition may be imposed if it's required for any custodial interrogation.
Withdrawing.
Lordship,
You want to withdraw it?
no, Lordship.
Then we'll reject it. Lord Mr. D. Megi, the Lord Counsel, appearing for the accused applicant, also for Mr. R. J. Borwar, large APB for the state. It is an application of the student, so you write. You should, write then. An FIR was lodged on 9/12/2025. To file. Release that on 9/12/2025. SI. On 25. You write, no, cut it, you write that on 9/12/2025, an FIR was lodged by one SI, Ranjit Chetri of Gauhati GRPS, to the effect that on 8/12/2025 at around 6:55, the police team received a phone call at around 6:50 p.m. And during the checking of passengers' luggage bag, they found 3 bundles of suspected fake currency notes of 500 denomination inside the black colored backpack from the possession of a person at the exit gate, Polton Bazaar, in bracket, Polton Bazaar side, Gauhati railway station. On receipt of the aforesaid information, the person admitted the same to be fake Indian currency notes. Also, the person apprehended, admitted the same to be fake Indian currency notes, okay? On inquiry, the person identified himself as Subhas Kumar, 25 years, a resident of Bihar, had procured aforesaid FICN from a person in Gauhati. The FICN apprehended were seized by the police. On receipt of the FIR. Guwahati GRPS police case number 179/2025. Under the under section 61 in bracket 3, stroke 318, bracket 4, stroke 62, stroke 178, stroke 171, stroke 150 of the business registered in the case of the council, preparing for the case applicant, submits the case applicant is inside the jail for last
78 days.
78 days, 78 days, and therefore further custodial detention in the instant case may not be required. Therefore, it requires the place for bail of the accused applicant at this stage. Full stop. The case diary in the instant case is available before this court, and in perusal of the scene, it was found sufficient incriminating material against the accused, prima facie material about the involvement of the accused applicant in the instant case. Taking into account the proceeding cremating material. This court is of the opinion that at this stage, the instant, at this stage, the bail should not be granted to the accused applicant. And again, the instant bail application is rejected.
The petitioners are in custody lodged. They are arrested on 15/8/2025. And since then, they are in custody lodged. And since then, they are in custody.
How many days?
189 days. More than 6 months.
Service has already completed, madam.
Hmm?
Service has already been completed, madam.
Service completed, they also took time to file a objection, but till date, they have not filed. Your lordship passed an order directing them to file on or before 19th, lordship.
Mr. Gogoi was appearing, Mr. Gogoi.
Page 12 is the FIR.
Okay, we'll list it on 26th. 26th will list. He is not there. Mr. Ahmed is present for the accused. Hmm?
Although the counsel for the respondent number 2 is appearing, I have checked lordship, but he has not filed any wakalatnama lordship for that your lordship may have.
Wakalatnama hasn't filed.
No, probably not filed. I have checked online lordship that document do not show any filing of wakalatnama.
Okay, we'll take it up in the next.
Rest we have directed to verify and
We'll take it up in the next.
Let me later, madam, you submit.
Let him come. Mr. Ahmed, the learned counsel for the accused applicant is present, as well as Mr. Ajay Bogwa, learned APP for the state. Over Mr. R.I. Gogoi, who appeared in the matter on the last occasion, is not present today. For the interest of justice, with the matter fixed on 26.
Okay.
This is regular bail application lottery. Petitioner is in custody lordship 79 days as on today lordship.
Huh?
79 days in custody today. 9 days. lordship.
9 days.
9 days. And since 7/12/2025. In custody lordship. Apparently lordship, FIR one thing is very much clear lordship. There is the love relation with the petitioner and the victim lordship. And as per the FIR lordship, and the 17 years old girl
Service completed, my lord.
and boy is
Yeah,
20 years old.
Madam, 183 settlements he has implicated, my lord.
Hmm.
After the incident, my lord, 3 was, my lord, he had to admit in a medical hospital, my lord. To make a kindly produce the, my lord, for 183 settlement.
Heard, Mr.
Yep.
So, Mr. The learned counsel, if you recollect his applicant, also heard Mr. Ajay Bogwa as well as L. Devi for, legal aid counsel, L. Devi, legal aid counsel, okay. This is an application of the so-and-so. Then you write, an FIR was lodged on 6/12/2025. 25 by the victim girl's mother, the mother of her. Who filed the FIR?
Mother of the victim.
Mother
Mother.
of the victim girl, who is allegedly of 17 years old. Full stop. It was alleged that the accused applicant for a long time had represented the girl, misrepresented the victim, misrepresented the girl, the victim girl, a victim girl as himself to be a Hindu boy. Full stop. It was alleged that on 6/12/2025, the accused took her minor daughter to Swagata Hotel at Vahakacharali, wherein wherein he had forceful sexual intercourse with the girl. It was alleged that due to the aforesaid incident, the victim girl got seriously ill, and she had to be taken to GMCs for treatment. Full stop. Next, after receipt of the FIR, the police registered the Vaihata Police Station case number 298/2025 under section 64(1) bracket 1 stroke 319 bracket 2 of PNS related to section 4 of POCSO Act. The learned counsel appearing to the accused applicant submits that the accused applicant and the victim girl were in love relationship, and both are young individuals. Full stop. People submits that the accused applicant has been arrested on
7/12.
on 7/12
2025.
7/12/2025, and he's already inside the jail for 79 days. That is, therefore, at these days, his custodial detention may not be required, and accordingly prayed for bail of the accused applicant. Full stop. This court has gone through the case diary that has been produced before this court, and having found incriminating materials against incriminating materials suggesting prima facie involvement of the accused applicant in the incident case, the prayer for bail application of prayer for bail is rejected at this stage.
Item 12,
Possible for timing. Vijay Chaudhary coming. Possible for timing.
Okay, time being.
14,
Maybe. This is not application under section 483. They are arrested on 20 January. And this will at the case only Washington Hardware at that Kopragar case,
Yes,
One-
Mr. Borua.
driving his vehicle and caused injury, accident. And one person of our side, we are Adivasi, our person died.
All of you are accused persons.
My lord.
All of you were traveling by the Scorpio.
No, we are not rural, we are villagers, Miller. The Scorpio was accident by which one of our Adivasi person.
So one of your Adivasi person
So
died.
our person came there and the driver and the other two person, they were flying away. So our persons were not called by the police to come to the police station for compromise. And when we were approaching the police station, they arrested us. This is the fact. And there is a huge rumor in this regard, and we are now prisoner. One is the student who is repairing Hashimi, so he has been given an entry. I produced one his admit card, and 2 is a teacher of high school.
So petitioner number 1 has been given interim and others are not given.
Others are
Hmm?
not.
One was granted interim only for the purpose of appearing in the
Yes.
exam.
Hmm.
So by some.
So what is there in the lead?
In the case there are sufficient materials. There were 3 persons traveling in the Scorpio vehicle. Then accident took place, then 1 person, the Adivasi person died. Now this accused person, they get out the vehicle, they pull out all the 3 persons, and they brutally kill the driver on the spot. The other victim, other two persons who were admitted in the hospital, they have identified all the accused person and they have implicated. Except the petitioner number 2, for petitioner number 2, there is a note of the investigating officer, kindly.
What is the note?
Actually the petitioner number 2, his name is
He is a teacher, his name is
Vishwanath Tudu,
Ah.
As per the IO note, my lord, the illegal, the note of the IO is that, my lord, he tried to stop the, my lord, other accused person who were, like, who were, my lord, allegedly,
So that is a note there specifically.
my lord,
That note is specifically there.
notice there, my lord.
Okay.
Only in
And
respect of-
what about this, this is, I think this is this,
Even, my lord, the person who was granted interim, my lord,
Mm.
he has also been implicated, my lord.
but he's 18 years or something.
18, my lord, only for the purpose of, my lord, examination, that is, also has probably granted him interim, my lord. But other accused persons, my lord, I have strong objection, my lord, because there are sufficient materials in the case there.
By submission, Miller, the IO called Miller, asked to the petitioner for complaint.
But the petitioner number 1 was given interim, and he appeared, let him go. And petitioner number 2 we can consider, but others we are not.
Others, my lord, there are sufficient materials.
Others we are not.
On fairly customary Miller for today, Miller, the 35 days.
How many days?
35 days.
35 days. No, I mean, this kind of, I mean, brutal killing of a person only because one person has died, it cannot be tolerated. I mean, you cannot
they-
take
they-
law,
they
you
excel,
cannot,
but-
take law like this on hand.
My
And they
submission, Miller,
and they
yeah.
keep on doing this.
Your
I
Lordship,
mean, they are Adivasis, that is perfectly fine. I mean, there may be certain, issues, but like, I mean, you cannot keep on doing like that. You bring all your people and like kill somebody, whoever you want. Cannot do
My
it.
submission, Lordship, there are two villages involved in this case, two villages. Adivasi village. One is Miller, the Gauri Nagar,
No, 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 no,
and
no.
the Twin Krishna Gaons.
Heard Mr. A. Rashid, the learned counsel,
Everyone
appearing
is
for the
very involved.
accused applicants. How many days you were there?
35 days.
39 days,
35.
35.
Five.
Heard Mr. A. Rashid, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Borwal, the APP for the state. This is an application under so and so, you write. Okay, then you write, an FIR was lodged on 21/2026 by one Boronda Bosumatari. Bosumatari, before the Kokraja police station, raising inter alia that on the evening of 19/1/2026 at 7 p.m., his son-in-law, Sikna Jhaulao Bismith, was driving his own Scorpio vehicle, registered number AS01GK 9152, and was coming from his walk with side groups, and when he was about to reach Odang Bajar, his vehicle met with an accident and thereby killed an Adivasi person. Semicolon, no, that on hearing about the accident, the local Adivasi people came in a group and attacked the vehicle and assaulted his son-in-law and other 2 persons who were inside the vehicles. Due to the assaults, the informant's son-in-law died on the spot, and 2 other persons were later on rescued by the police. Full stop. On receipt of the FIR, the police registered the Kokrajhar PS case number 12/2026 under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that applicant number 1 is a boy of 18 years and who has already been granted interim protection by a coordinate bench of this court by this order dated 6/2/2026, and accordingly he has already appeared before the police.
Right.
Appeared before the police and got his statement recorded.
No, I'm the court, I was interim, so court granted.
Huh?
The action was not from the court. Honorable court,
What is he saying?
CGM granted bail.
So you have appeared before the police, huh?
I-
Huh? What CCM, what is he saying?
CGM granted, released me, and then I am appearing.
That's what you are appearing, na?
I am.
Interim protection given. Then you write, he further submits that accused applicant number 2 is a teacher and he is not involved in the aforesaid incident. Rather, he tried to stop the violence activities committed by the violence activity alleged to have happened there. Alleged to have occurred there, you write occurred there, nah? Occurred there, full stop. He further submits that since the accused applicants are already, the remaining accused, other than, he submits that other than accused applicant number one, all other accused applicants are behind the bars for last 35 days. And taking into the length of detention, he prayed that the accused applicants should be allowed to go and bail. Next, on the other hand, Mr. R.J. Borua, the learned APP, has submitted that there are sufficient materials about the involvement of the accused applicants in the instant case. However, he submits that there is however, there is a note from the investigating officer that as far as the involvement of accused applicant number two is concerned, that is doubtful, as it is stated that he tried to stop the violence, full stop. Next para, taking into account the incident, the incident wherein a heinous act of killing of a person by a group of people is group of people, full stop. Group of people, this court is not convinced at this stage to grant bail to other accused applicants except accused applicant number one and two, full stop. Accordingly, it is directed that the interim order so passed earlier, provide order 6/2/2026 in respect of accused applicant number one is to be made absolute, full stop. Further, it is directed that the accused applicant number two shall be released forthwith on furnishing of a bail bond of rupees 20,000 with a surety of like nature to the satisfaction of CJM Kukrazar, subject to the condition that the accused applicant number two shall cooperate with the investigation and make himself available as and when called for by the investigating officer, full stop. In terms of the aforesaid direction, the instant bail application is disposed of. The last line, the prayers for bail of all other accused applicants except the aforesaid two accused applicant are rejected, is rejected.
At this stage.
Hmm?
At this
At this stage.
15.
Maybe, certainly.
My lord, steps not taken in this matter, office note reflects, my lord, on POCSO matter, my lord, on. Definitely, office note applies.
Take steps, why are you not taking steps?
But step already taken.
Okay, the office note reveals that no steps for service of notice upon respondent number two is yet to is taken. It is directed that the learned counsel it is directed to the learned counsel appearing for the accused applicant that steps should be taken within a period of 3 days. Let the matter be listed on 10th of March.
Nice.
Timing at 12.
Yeah, no issues.
But to see a regular pay in my lord, all family members dowry death, my lord. Father, mother, husband, all are in jail, my lord, and your lordship will find number one is for last 8 months. Number two are also almost, my lord, same. For 4 months, 14 days. Your kindly see the FIR, my lord, page 13. Total 5%.
So, Moinul Islam is who? Who is he? Is the father?
The father-in-law, that is father.
He is father-in-law.
Father-in-law.
Rabijan is
Father-in-law.
mother-in-law and Iqbal is a son,
Iqbal is the husband, that is son.
husband of the victim.
Yes.
Okay.
So number one is my for last 8 months.
Hmm.
And rest are about 4 months,
Okay.
more than 4 months, my way.
Okay.
Tax sheet filed and third yet is third,
Okay. FIR is at page 13.
page 30. Page 30. Page 14 bottom.
Yes,
Page 14 bottom, husband was not present. You look at page 14 bottom. As per FIR. He works in a my road here at Gauhati, sorry, Ojai. Yes. In the last
accused number 5,
five. That is a husband, son of the place number 1 and 2.
accused number 5.
Bob.
But allegation is against him also, Mr.
Now against him conspiracy.
Conspiracy.
So
to-
I am not married at this stage, my lord. On two counts I am the whole worship. One is because already everything is fine, my lord. And father, mother, all the family members and custody, I am not on the, my lord, on married at this stage, my. Only, my lord, if about eight months. More than 7 months, my lord. And now kindly see on other ground for page 42. Arrest memo kindly see. Page 42. Nature of the witness, my lord.
Yes,
My lord, around 2 years, 2 months of them after marriage, my lord, the incident happened. When my mother, my lord, petitioner number 2, called his son, my lord, Iqbal, he advised them to cut, she was hanging, my lord. She was hanging, to cut the rope and throw it somewhere. So accordingly, my lord, father and mother cut the rope, laid on a body and threw the rope in the river. Subsequently, the father of the deceased arrived and they seen the ligation mark in the neck and then inform police for the first blood. That is the yes. At that point, he was not there. Husband was not there. Father and mother were in the house, and others witness also stated that
you have the case there.
this year.
This year,
But
TC.
trial not yet started. Here up to up to 1510. Up to 1510.
You just give me that copy. I'll just.
Just
Only one thing can we see your lordship. FIR is dated, made registered on 20, 20. 20620. Date of occurrence is 16/6, my.
16/6 and 20.
20. 13 PWs, my lord. So there is no immediate chance of problem.
last order in the 1210, it was fixed for 2410 for production only. Subsequently, it is not updated. That is.
But 3126, my lord, we got the information, summons issued to the witnesses.
All of them were arrested in the same date, right?
No.
No,
Mother and
he was arrested.
the petition number 2 and 3 subsequently arrested. Madam.
2 and 3.
After around 4 months.
Who were arrested at the same time on the,
Petition number 1, Moinul Islam.
Yes, what is that? 18/7/25. Petition number 1. And petition number 2, 12/10/25. Petition number 3, 10/10/25.
Incident of June, madam, 16 June.
Hmm?
Incident of June.
June.
All were explaining, madam.
And the rest memo is your lordship, we have annexed that one, page 42 onwards.
but there is no witness in the arrest.
Otherwise also, madam,
Hmm?
8 months, other month.
Charge sheet is also my lord.
And sections against you are registered under
Yes.
Dowry Detention.
80 sub plus 2.
To is dowry death, madam.
We heard Mr. H.R.S. Chaudhary, the learned senior counsel, assisted by so and so. For the accused applicants, also heard Mr. K.K. Parasar, the learned APP for the state, decision application under so and so. An FIR was lodged on,
It is made by the register and soon.
hmm?
It is made. Procedural page. Vernacular registry. Page 18 vernacular registry.
So FIR was lodged on 26.
Oh.
26/2023.
Registered on 26. Page 16, your lordship, see vernacular. Page
No,
1.
Page 18, it says 20,
Yeah,
but vernacular, there is no date.
No, that is untrue. Registered only bottom, your lordship.
And FIR was registered on 26/2025. On a complaint by one Helaluddin. Who is Helaluddin?
Father of the victim.
Helaluddin, the father of the victim, alleging inter alia that on 4/8/2023, his daughter, namely Kohima Begum, was married to the accused applicant number 3. Accused applicant number 3 as per Islamic rights, and his daughter got pregnant thereafter, and consequently given a birth to a girl child, who was 9 months old at the time of filing of the FIR. Semicolon that soon after the birth of the girl child, the accused applicant number 1 and accused applicant number 3 allegedly started harassing the victim girl mentally and physically for dowry. That then semicolon that facing with such demands, the father, the informant, had given ₹30,000 at one time, and subsequently another amount of ₹70,000 to the accused applicants. That on 14/6/2025, his daughter informed him over the telephone that the accused applicants were torturing her for more money. Semicolon, that on 16/6/2025 at around 4 AM in the morning, accused applicant number 2 and accused applicant accused applicant and another accused and another co-accused informed him over the phone that his daughter was not keeping well. And thereafter, 10 minutes later, the accused applicant number 3. Thereafter, accused number 3, 1 Rashida Begum informed him over the phone that his daughter expired. That after receipt of the news, he along with the informant along with his family members went to the house of the daughter and saw his daughter lying on bed and noticed marks of strangulation on her neck and signs of assault on her body, and immediately verbally intimated the same to Longai Police Outpost. Semicolon, that it was stated that accused applicant number 5, the husband of his daughter was not present at that point of time and he was in district Hujai for some work. However, it was alleged that there was a conspiracy wherein accused number 5 was also, accused applicant number 3 was also involved, full stop. Mr. H.R. Chaudhary, the learned senior counsel appearing for the accused applicants, submits that the accused applicant number 1 was arrested 8 months back and thereafter the accused applicant number 2 and 3 were also arrested 4 months back. He submits that charge sheet in the instant case has already been filed and there are how many witnesses?
13.
And there are 13 witnesses.
Not a single witness is examined.
There are 13 witnesses have been named in the charge sheet and till date, not a single witness has been, charge has been framed. Charge framed?
Charles Plain, my lord, next date is 27/2.
Okay, till date, right, though the charges have been framed, till date, none of the witnesses have been examined. He submits that, taking into account the length of detention as there are 13 witnesses named in the charge sheet. The trial will take considerable time, and therefore he submits that the custodial detention of the accused applicants at this stage may not be required. First of, he submits that the accused applicants will attend the trial and cooperate with the trial as required. First of, Mr. K.K. Parasad, Alanik IPP, has submitted, has opposed the bail application at this stage, as none of the witnesses have been examined till date. None of the PWs have been examined till date. Taking into this court has considered the TCR that has been produced before this court, as well as the submissions made by the counsel appearing for the respective parties. After taking into account the length of detention of the accused applicants, and of the fact that none of the PWs yet none of the categories are examined as yet. This court of the considered opinion that further custodial detention of the accused applicants may not be required at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith on bail on furnishing of bail bond of rupees 30,000 each each with security of like amount to the satisfaction of the additional session judge FTC Sirubhumi, subject to the following conditions that the accused applicants shall cooperate with the trial and appear shall appear before the trial as and when the date is fixed. An accused applicant shall not try to rewind the right deadline. In view of the opposite direction, the instant bail application is disposed of as allowed.
Malat, in summary, Malat, one line, Malat, regarding my objection, Malat, that they have tried to manipulate the evidence, but Malat, cutting the rope, it throw it to the river.
And then you write that then the learned APP also submits that the accused applicants tried to manipulate the whole incident by showing it as a suicide date.
No, by showing he died as an illness because due to illness.
By showing that the victim died of illness. But it was alleged what? Suicide or strangulation? It was strangulation, they alleged.
It is in the postmortem report, ligation mark is there, continuous or non-continuous, it is not there. Because of that, it was sent for FSL.
Number 17.
Seventeen also, as per office note, steps not taken.
Steps taken, Lordship. Most of the report has not taken. We have taken steps. Scan copy has already been received, but.
Steps not taken, Mr. Putta.
No, steps received on 16th to.
You verify with the registry, it's which there is no note. Heard Mr. S.K. Poddar, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APV for the state. The office note dated 20/2026 reveals that scanned copy of the TCR has been received. However, there is no report of taking any steps for service of notice on respondent number 2. The learned counsel for the accused applicant is directed to take fresh steps within a period of 2 days of passing of disorder. Let the matter be fixed in the second week of March.
Update में kindly, Lordship, if possible. Because
12th of
boy
March.
is 18-year-old, Lordship. The accused is 18-year-old.
You'll have to take some time. No,
No.
boy, doesn't matter.
That,
Boy,
Lordship.
you have not taken steps.
Somehow.
It has notice has
Can
to
be
go.
on 5th of May or 6th
No,
of
no,
May.
no, no.
March.
It will be on
March or
12th
6th.
12th of March. On 12th of March. You take steps first.
Please, your Lordship. Lordship, case there was called for.
Lordship, we are filing objection today, Lordship. Lordship,
Okay, heard Mr. B. Medhi, the learned counsel appearing for the accused applicant, also heard.
M. Deka.
M. Deka, the learned counsel appearing on behalf of Mr. S.C. Kyle, the learned. This is against whom? You are appearing as
Custom, Lordship.
Customs, the learned S.C. Kyle, the learned standing counsel, Customs Department. The learned M.S. Deka submits that they are going to file an objection in the instant case today. They have raised for some time. Let the
Shortly,
matter be listed on.
second occasion.
uh,
The day after tomorrow, Lordship.
on
There is a violation also, Lordship.
on 11th of March.
Lordship, kindly short date may be fixed, Lordship. Today they are filing the objection, Lordship. Lordship, day after.
2nd of March, okay, 2nd of March. Not before that, 2nd of March,
Shorter, Lordship.
2nd of March. Before that, it will be difficult, Mr. Madhu. Lot of matters have been fixed. I mean, you are not, it's not only your matter.
I'm sorry, other matters in item 17, steps they have taken, service is
But there is no record, so. Then you write, those steps have been taken in the matter, the report of service of notice is not yet received. The learned APP to take instructions about service of notice on respondent behavior. No, that cannot be. No, that cannot be. That will be difficult, Mr. Potter. Lot of matters have been fixed. It won't be possible to take.
He's behind the bar for more than 6 months. My concern is that he is a student and he is actually only next.
See, all the cases are like this only, Mr. Potter. Which case to be preferred, which case not to be preferred, all have to be balanced. So, I mean, we are giving the dates on the basis of whichever is this thing. Otherwise, it would have been a problem.
I have to appoint again, my thus, that's the problem, Lord.
No, correct, but that is the process we'll have to follow. It is to be done. And already I mean, the dates are full. Otherwise, there is no point we would have given him in a later date. Would have definitely.
Regarding item number 18, Lordship, can it be on, instead of second, Lordship, can it be on 27?
No, not possible. I said not possible. If it would have been possible, I would have given it at a first instance. only.
That's reasonable.
19, my lord, we received a CD, my lord, related to cybercrime, my lord, 24 FIR, my lord, many were, my lord, this voluminous, may it be, my lord, after some time, or at 2, my lord, because I need
No,
to.
no, some other duty, we go through it.
My
I
lord,
mean, that will take some time.
My
If such a voluminous,
my lord,
heard Mr. Anuddin, the learned counsel appearing for the accused applicant, also heard Mr. M.K. Bushra.
K. Bush,
K. Bushra, sorry, K. Bushra, the learned APP for the state. Mr. Bushra submits that he has received the case diary, which is very voluminous. He has received the case diary today, which is very voluminous, and he needs some time to go through the same. Accordingly, time is allowed. And fix the matter on second
second, my
of
lord,
March.
my lord, deeply, CD to be retained, my lord,
CD to be retained.
my lord, deeply obliged, my lord.
20.
May it please your Lordship. 483 application, my lord, for regular bail. Petitioner is behind the bar since 41 days, my lord, as on today, my lord. Page 7 is the FIR. Allegation is a theft, my lord.
Allegation of theft, my lord, 3,50,000 gold jewelry and one mobile phone was taken. Subsequently, my lord, that is the mistake, my lord. They have taken a mobile and they try to open the mobile and some message has come in the email. And police got the information, my lord, from his house, the gold jewelry, some gold jewelry and the mobile and some other articles, but money is not there. Well, seized from his house. So he's
41 days.
Maladia. That is there. But money 3,50,000.
Not recovered.
Not yet recovered. Other articles. will be-
So he has learned the mistake now. Next time he will not open the mobile. And he will not touch anybody's mobile.
Nowadays, mobile, my lord, if try to, my lord, in the email, my lord, some messages come, my lord.
But 41 days,
My lord,
it can go, I mean, then.
not to
Fine.
repeat subscriber activities. my lord.
Hmm?
Not to repeat subscriber activities, but these people are, my lord,
Heard Mr. So-and-so learned counsel appearing for the accused applicant, also heard Mr. PKK Parasal and APP for the state. This is an application under so-and-so. And the allegation against, the FIR was lodged by one Rupam Bora on 13/1/2026, stating, alleging that 12/1/2026, about 11 AM, someone came, some miscreants entered his house and committed theft of cash amounting to rupees 3,50,000, gold ornaments and one mobile phone without SIM card. On receipt of the FIR, police registered Gauri Sagar PS case number 1/2026 26. Where is this Godisagar place? Sipsagar. Mm, mm. Registered, huh? Registered, upon investigation, the police, the police got a clue through the mobile phone, which was alleged to be stolen by the accused applicant, and on reaching his house, the police recovered gold jewelries from the mobile phone from the accused applicant. Full stop. The accused applicant is already 41 days behind the bars. Full stop. Next paragraph. The learned counsel prays for bail of the accused applicant since he has already spent 41 days behind the bars and he doesn't have any criminal antecedents. Criminal entity, earlier criminal antecedents. Full stop. Learned APP is a K. Parasa opposed the bill, submitting that though the gold garments have been recovered, the money is yet to be recovered and investigation is still going on. Full stop. Next paragraph. Looking into the whole matters into entirety and also the length of detention of the accused applicant. This court will have to consider the opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of rupees 30,000 with a security of like amount to the satisfaction of the CGM Sipsagar, subject to the following condition that the accused applicant shall cooperate with the investigation and shall not try to influence any witness involved in the instant case. In view of the aforesaid direction, the instant bail application is disposed of.
Clear.
Bail hearing, I think 25.
Is an interim sitting officer.
CD of receipt. Let the matter be listed.
12
12th March. Interim order so passed earlier shall continue till the next date of listing.
26.
For people application, the 6th of the city not received.
Hmm?
Interim is there, man.
CD not received. Interim order so passed earlier shall continue.
13th of March.
Interim order passed on 13. Passed earlier shall continue to the next date of listing. Later matter will be listed on 13th March.
27.
May I please your lordship? Lordship, this is anticipatory bail application, lordship. Lordship, the FIR starts at page number 11. The vernacular is at page number 15. Lordship, the basic allegation against me is this, that I have abated my wife to commit suicide, lordship, which is false, lordship. Lordship, I am on interim, lordship. I have appeared before the investigating agency and my statements have been recorded. Lordship,
Yes.
But we have received the case diary, my lord, as part of my lord, statement of the witnesses, my lord. These accused person, my lord, they are having relationship since last 4 years, my lord.
she's my wife,
In the-
lordship.
Let me complete this. In the last year, 2025, my lord, they have also solemnized court marriage, my lord. After that, my lord, when their marriage was fixed socially, my lord, then, my lord, this accused person is postponing the date, my lord.
Hmm?
He is postponing the date, my lord.
Mhm.
And, my lord, there is also allegation that he demanded money, my lord, to perform the marriage, my lord.
Lordship,
And as part of postmortem report, my lord, the final cause of death has not been ascertained, my lord. because my lord, the FSL report has not received. He has appeared, statement recorded.
Let him remain in bail. I mean,
Let him, my lord, cooperate.
he'll co-
I'm
he'll-
cooperating, Lordship, and I've been cooperating, Lordship.
Heard Mr.
PP Methi, Lordship.
Mr. PP Midil, Learned Counsel, appearing for the accused applicant, also heard Mr. R.J. Boro, Learned APP for the state. There is an application under so and so. An FIR, an FIR was lodged on 1/10/2025. 25. Alleging. Can you write like this? The FIR dated 1/10/2025 was lodged leading to this case, in which it was stated that the informant's sister was staying in a rented house of one Manosi Busumutare and was found hanging. It was further stated that his sister had solemnized court marriage with the accused applicant, and the date for traditional marriage ceremony was also fixed, but the accused applicant demanded rupees 5 lakhs and tried to delay the traditional marriage. Due to the aforesaid fact, the victim suffered mentally and ultimately ended her life. It is seen that a court bench of this court, by order dated 8/1/2026, has allowed the accused applicant to go on interim bail, and in terms of the aforesaid interim protection, the accused applicant has already appeared before the investigating officer and got his statements recorded. The Learned Counsel, appearing for the accused applicant, submits that he is fully cooperating with the investigation and will also cooperate the investigation in future. Full stop. Therefore, his future full stop. The Learned Mr. R.J. Boro, the Learned APP, on the other hand, opposes the bill, submitting that there are materials in the case diary which suggest active involvement of the accused applicant in abating the suicide of the victim girl. Full stop. This court has gone through the case diary that has been submitted before this court, as well as heard the submissions made by counsel appearing for the respective parties. On consideration of the matter in a wholesome manner, this court is of the considered opinion that the interim protection granted by order dated 8/1/2026 should be made absolute at this stage. Accordingly, the same is made absolute in the same terms and conditions as mentioned in the order dated 8/1/2026. In view of the aforesaid direction, the instant the application is disposed of as allowed.
MDP of the Lordship.
30, we have not received the case diary today, my lord.
CD not received, let the matter be fixed
Yes.
on
Lordship.
fixed on when?
My lord, 2/3, my lord.
Oh,
2/3.
2/3.
Lordship,
Okay, both sides are represented.
Lordship, I am for item 30, Lordship. Last occasion I have error regarding her mental disorder, Lordship.
No,
I
but
have
let
this-
the case diary come, we'll hear it on second.
No interim is there, Lordship. He is the husband, he has to look after 2 minor child, Lordship. And
No, we are giving him a short date, Mr. Second,
Okay,
let
this
it
is-
come, because otherwise
Second of-
it will be difficult to execute it.
Lordship, kindly see the.
No, that's what I'm
Very much
saying.
clear,
We are giving it on to second. So let the CD, without CD, it will be difficult. Let, Mr. Borwa, CD, second.
Lordship, 17 days
I
later.
understand, this AV application, but I mean, materials suggest that the court should go through the CD in this case.
Actually, I
Without CD, it
I
will be
didn't
difficult.
annex these documents. Right now, I have.
It will be
collected.
difficult without the CD.
Okay.
I have already expressed my mind,
Okay.
so don't insist. Let the matter come on
Okay.
second. Okay. No, same, second.
31.
31, my lord, at 2 p.m., my lord. 31 at 2 p.m. my lord.
One has already been given.
After something?
After something. He has also appeared. He has also appeared.
32.
So, my lord, we have we received a report, my lord. No cases pending, my lord, against the present petitioner, my lord.
Hmm?
No cases pending, my lord.
Then why this petition application?
Your lordship, there's a mistake in the petition. The police case number is written wrong. The correct should be two.
You have wrongly, I mean,
Let him file fresh bail application.
you withdraw it and file a fresh one.
Your lordship, I could.
And how you
file
have
a
been, and you have been granted interim?
No, lordship.
No interim. Okay, then you withdraw this, you file a fresh one. Your name,
Sanskriti Barua.
Sanskriti?
Barua.
Okay, I heard Mrs. M. Borua, the learned counsel appearing for the accused applicant. She submits that there is an inadvertent typing error in the anticipatory bail application, to the effect that the case number has been mentioned wrongly. In view of the aforesaid mistake, she submits that she should be allowed to withdraw this instant AV application to fresh a file, to file a fresh one. Where is allowed, the instant AV application is dismissed as withdrawn.
Before.
Is there not, both the parties represented, is there not proceed, let the matter be fixed on?
Short that maybe fixed.
Hmm?
Short that maybe fixed.
When 26th,
Now is that.
Mr. Borua?
How is that?
26 of
Lahori-Ghat, madam, Lahori-Ghat district,
Hmm?
9 or 10.
AB application,
9-3, madam.
AB application,
Interim of- Interim.
no interim.
6, madam.
Huh?
6.
Okay,
6,
let the matter be fixed on 6th of March.
He's not.
6th of March.
Bless.
35, my lord, case diary not received, madam.
None appeared for the petition, none appeared for the accused applicant when the matter was called for. The learned APP submits that CD is yet to be received. Let the matter be fixed on
9-3.
9th March.
For admission action number 5.
Come on.
Bail खत्म नहीं, बिलिंग 9 आवर खाली तमाम पास होगा ऐसा. Yeah, yes.
Senior is coming.
Huh?
Lordship senior is coming.
Who?
M Khan. M Khan.
Pass over.
36. Item number
5 your lordship will take that.
Huh?
Yes, I mean item number 5. your lordship.
Is 5 has been called, isn't it? Is it 5 or 4? 5.
5.
Yes.
Herein a petition was filed for taking Zimma of his cash amount, your lordship. Rupees 2 lakh was seized from the house of the petitioner,
Hmm.
and for a petition of
You are challenging which order?
page 26, your lordship.
Please,
Page 26.
26.
And that's 5, page 20. Last.
Yes,
In here, your lordship, the report was called for from the IO of this case. Your lordship.
hmm?
In the last occasion, report was called for you.
Report was called for.
Yes.
Is there any report?
Report no to same, my lord. Some time may be allowed for it.
No report has come. Heard Mr. A. M. Khan, the learned counsel for the petitioner, also heard Mr. R. J. Burwar, learned APP for the state. Provide order dated 13 to 2026. A coordinate bench, this court has called for a report from the investigating officer in the incident case. What report exactly it was it?
I think this is such case, your lordship, but
Hmm?
No, it is,
Rashid
if it
has-
is search my lord, then scan copy may
Yes,
be called for
yes.
my lord. It
Yes,
apne
yes,
hamse
yes.
bole na. Search case my lord, police cannot give
presently,
any
your
report.
lordship,
my
the
lord.
police has no report, your lordship.
Then, I mean, why then, I mean, this call for a report of the investigating
I think-
officer? It was very recently on 13. When was the charge sheet filed?
I don't know that, your lordship, but I have
But lordship may call for a scan copy of the
yes,
my lord,
this
special
year may be called for.
special case number 56 M 2024. my lord.
TCR is filed, na? I mean, charge sheet is filed.
Yes,
My
yes.
lord, yes, my lord. That is the case has been registered, my lord.
Okay,
Revision.
you write, it is submitted, by the learned APP. Don't write report on this. Huh? It is submitted by the learned APP. The charge sheet in the instant case has already been filed. Therefore, PCR in the instant case should be called for. Accordingly, the registry is directed to call for the PCR in connection with
Special
in bracket NAR case number 56
M.
in bracket M of 2024 from the learned
Special,
session judge.
special judge Bongai.
Here it is the session judge.
In bottom, your lordship kindly see, special judge.
Okay,
Bongai.
special judge Bongaigaon. Let the matter be listed in the second week of March, third week of March. Third week of March.
Orders, I think 36.
May please the lordship, appeal against acquittal lordship, the original SDR has been received and the matter may be fixed for hearing lordship.
My lordship, matter will be taken after some time.
Why?
Lordship, because actually this appeal is not live. The magistrate, the appeal is filed by the order against filed by the learned.
Later, I mean, that will require hearing, isn't
Hearing,
it?
lordship.
So, I mean, it is just come for order, that will require hearing.
Then
So-
fix
so-
for admission hearing. ma'am.
Then I will put it for hearing. Heard,
Miss B. Goswami,
B.
Goswami.
The learned counsel appearing for the petitioner, appellant, also heard
R. Begum. R. Begum.
R. Begum, MS R. Begum, you are appealing for whom?
Just one name.
For the respondent. TCR in the instant case has already been received. The registry prepare the paperwork for the paperwork in the instant case. Let the matter be after preparation of the on preparation of the case, I mean on preparation of the paperwork, let the matter be listed for hearing. In the hearing after 3 weeks time. After 3 weeks, 3 weeks will be sufficient for paperwork. How much? 4 weeks, 4 weeks, after 4 weeks. 4 weeks.
If any day.
Paper book will have to be prepared, so 4 weeks. Huh? Yes.
47.
The LCR of receipt lordship.
Hmm?
LCR receipt lordship.
Yes.
There is the IL lordship for suspension of sentence lordship.
POXO matter.
POXO matter, and whether service is complete or not, we have to already taken a step, Lordship. So registry, and as well as we send us a copy of,
You know, why this matter has come before this bench?
there is a notification,
It's a division bench there, I mean, it has been heard.
one notification is the, there is a one notification here.
Well,
Flag mark, there is a flag mark.
okay,
More than 10 years,
perhaps we listed before single bench wide notification.
one notification also, and the test.
Okay, this one. What is your this thing here? Conviction, I mean, sentence?
10 years, Lordship.
Huh?
10 years, Lordship.
So, I mean, only more than 10 years will go to the.
Go to division.
Hmm?
Yes,
More than 10 years.
yes. 10 years imprisonment, and fine of rupees 10,000 under section 4 subsection of POCSO Act. Further convict and sentence to imprisonment, fine of rupees 500 under section 341 IPC. There is a IA Lordship, there petitioner behind the, petition that for 414 days. What is your thought, Litigant? In this case, the Lordship,
See, objection was supposed to be filed.
objection is supposed to be filed there.
Objection was supposed to be filed. You file an objection in the case. In the IA.
Till that, no.
No, they let them file it.
In file.
And we thought that
Mr. R.J.
there is a
Borwad,
IA
a learned APP appearing for the state, submits that though time was earlier allowed, though as per the records, time was earlier allowed for filing an objection. No objection has been filed as yet. He prays for some more time to file an objection in the IA. Also, prayer is allowed. Let the matter let the matter be listed again. On when? 16 March. In the IA, you write this, huh?
So there is, whether there's a notice of the SAP or not, that may be. Notice, Lordship, that's number 2.
Correspondent 2 is also there. Huh?
Whether it is complete or not, that can be.
Actually, notice was not issued on the student number 2.
Already issued, Lordship. Notice issued. We have taken a step on.
14/11/2025,
Huh?
We have,
maybe 14/11/2025 order.
we have step taken on 21/1/2023, and we have also served a soft copy as per this honorable order.
IA, whether you have taken notice, I mean, you have taken any steps. There is no order.
Appeal memo, Lordship. In appeal memo, there is a order, Lordship, on 15/12/2020, there is a order direct.
15/12, there is an order of admitting the appeal call for the PCR issue notice returnable 4 weeks.
There is a soft copy, there is a direction, there is a soft copy sent. As well, As per the direction
Then
of,
respondent number 2 was directed to be served.
Same day, madam, we'll also have the instruction, madam, regarding service of notice.
we have also sent a soft copy to the PP office person.
Okay, the learned APP said also take instructions about service, about the status of service of notice on respondent number 2.
Master.
We will come back in 5 minutes.
Madam.
Also, this matter was, now, we lost the, missed the file in somewhere. But last time, the man is either dead or alive, no information. We wrote the letter also, there is no connection at all. So I humbly pray that if the PP can help, whether the man is really still alive. If he is dead, then it will become infectious. 2011 matter, very old matter. No, since then he filed the case, got the stay order, then there is no trace of him, last 15 years.
You could not contact him.
We wrote a letter, we couldn't contact at all.
So what is to be done now?
Only way out is, my lord, if the PP through police can find out whether he is alive or not.
How police will find it?
Police can do that. Can do that.
Mr. Borua, what is to be done?
Send a message to police and find. Can help. He really hates others.
আপনাদের খবর আনিব লাগিব আমরা তো পুলিশ আনিকে খবর নকৰিব না মানুহ বহিছে আপুনি যদি ডেথ সার্টিফিকেট দিয়ে তাহলে আমি খবর কৰিব Hello, if he gives any death certificate,
He's saying
then
that
we
he
can
could not-
verify it, my lord.
Huh?
From the death certificate, we can verify whether the person is.
But he's saying he could not
But,
contact.
my lord, whether the person is alive or not, where is, how can the police go and, my lord, give a report, my lord?
We can give you some more time. He tried to find out. Otherwise, I mean,
My junior will have to go personally.
he'll have to find it out somehow.
Yes.
Heard Mr. R.P. Sharma, learned senior counsel, assisted by MS M. Bora, the learned counsel for the petitioners. Also heard Mr. R.J. Burwa, learned APP for the state. Mr. R.P. Sharma praised for some time as praised for some time as he could not contact the petitioners in the instant case for a long time. In view of the aforesaid submission, let the matter be fixed let the matter be fixed after 4 weeks. After 4 weeks to enable Mr. R.P. Sharma to get in anyways, you write like that only. Let the matter be fixed after 4 weeks.
39.
This is a revision petition, my lord.
Yes.
I am for the revision petition,
Which is the impugned,
my lord. The brief facts is that, my lord, Krishna Gopal Das, the opposite party here, filed a complaint alleging that I borrowed rupees 13 lakhs from him by executing a promissory note.
executing?
13 lakhs,
No, executing what?
promissory note.
Promissory note. Okay.
Thereafter, my lord, he wanted the money to be,
Hmm?
he wanted the money to be returned.
Yes.
And after repeated request,
Hmm?
after
Hmm.
repeated request, as
Hmm.
I failed to return, he filed a complaint under NI Act before the learned CGM Borpeta. Thereafter, my lord, complying the formalities, the trial began in the court of learned additional 6 judicial magistrate Borpeta. On completion of the trial, the learned court below passed the judgment
on 18/1/2014 and ordered rupees 13 lakhs to be paid back to him, and also SI for 1 year.
For
SI,
SI for
1 year,
1 year.
1 year, my lord.
Hmm.
Thereafter, we appealed before the Sessions Court, and in the learned Sessions Court, the case came to be tried in the court of the learned additional session judge. The learned judge, after hearing both the sides, held that I am liable to pay rupees 6 lakh
By order dated
by order. dated-
21/4.
Judgment, yes.
My lord, it is 21/4/15,
So it was partially upheld.
partially appeal, my lord. And now, my lord, what happened?
Yes, direction
The-
to 6 lakhs.
6 lakh,
What about SI?
SI for 1,
SI for
SI for 3 months,
3 months.
3 months. my
Okay.
lord. This is the final observation at para 31 of the judgment of the learned.
Para 30,
31, para 31,
para 31, page 31.
para, my lord, para of the judgment.
Okay,
of the
para of the judgment.
Additional session judge.
Mhm. 31, yes.
My lord, it reads,
Yes, yes.
it reads, in the result, the appeal is partly allowed. Accordingly, the sentence of the trial court is modified to simple imprisonment for 3 months with fine of rupees 6 lakh. In default, 1 month simple imprisonment under section 138 of NIR.
You are Mr. Alam.
My lord,
You are Mr.
Alam, A. Alam.
Alam. Yes.
My lord, our submission is this, my lord.
Hmm.
We want to pay the amount. If the honorable court so pleases, it may be allowed 6 months' time. In 3 installments, we are ready to pay. And the other part of the prayer is, my lord, the honorable court may be graciously pleased to exonerate this petitioner from undergoing the substantive part of the sentence, that is simple imprisonment for 3 months.
So you are praying for 3 months, 3
Like
months
that,
SI exoneration and,
My lord.
and the money to be paid within 6 months.
Within 6.
Yes. Yes, Mr. Wanta?
My lord, let them come with him and concrete, my lord, petition that this is the petition, my lord, then I'll.
If they can file an affidavit,
My lord, then I'll take.
By way of
instruction
an affidavit?
I'll take instruction my client. Then, my lord, make him be closed.
yes, you file an
Sir,
affidavit,
file an
bring it on record that you're willing to do,
Yes.
correct?
If required, your lordship kindly keep it part, no problem.
No, I mean, that can
Because
be.
I think good enough, because already for 2015,
Mm.
the last 10 years is pending here.
Okay, I heard Mr. A. Alam, the learned counsel appearing for the appellant, appearing for the petitioner. Also heard Mr. T.J. Mohanta, the learned senior counsel,
Respond number 2.
assisted by so and so for respondent number 2. Then, Mr. Alam, the learned counsel appearing for the accused applicant, appearing for the petitioner, submits that in terms of the judgment dated 21/4/2015, the petitioner is willing to pay. A petitioner is willing to pay the amount of rupees 6 lakh as directed to be paid by the aforesaid order. And he pay the amount, so it's pay the amount, full stop. He further submits that this court should allow him at least 6 months' time to pay the aforesaid amount. And he also prays for exoneration of the simple imprisonment of 3 months, which has been sentenced by the aforesaid judgment dated 21/4/2015. Full stop. Taking into
Last-
account,
Last week of March.
taking into account the submissions made by the learned counsel appearing for the petitioner, this court is no, don't write taking into account, then you write, accordingly, he submits that he would file an affidavit to the effect of his submission made before this court. Full stop. Accordingly, let the matter be listed on 24th March,
No.
on 24th March,
25th, my lord.
25th March, 25th March, by that date, by that date, the petitioner will file the aforesaid affidavit. Full stop. Let the matter be listed on 24th to 24th March.
Timing item number 31.
CD has come with interim bail. FIR is at page 20.
Statement to more one,
Accused number one is on bail. He was, both were suspended. Accused number one has been terminated and the present petitioner has been reinstated in service. And his role is only for the purpose of processing the law. He has nothing to do with.
Yes, Mr. Parasar?
My lord, yes, fact is that, my lord, for 42 numbers of tractor, loan was disbursed from the Punjab National Bank. Now, my lord, entangle the bank officials and the one tractor dealer. There are statements of the victims against whom loan was sanctioned. So they were asked that you will give you loan and without any down payment, you will get the tractor. They have submitted the documents. Subsequently, the persons who, some agents are also there, so you have to pay 1 lakh. So we cannot give 1 lakh, then return the document. So they return the document, but for those documents, the loan process initiated. So accordingly, 42, against 42 numbers of tractors, loan is sanctioned from Punjab National Bank, money disbursed from Punjab National Bank to the tractor dealer. But no tractor were delivered. Subsequently, when bank gave notice to those persons that you pay the money for any EMI, so none has been paid because we have not received any tractor. Now, this person, Vishnu Prasad Behera, was the agricultural officer of the bank. He was to any agricultural loan, he has to
It has to go through him.
he has to verify. Subsequently, the branch manager will. Now, statement of the branch manager that I am newly engaged, he stated that I have depend upon him, his statement. He said, I have all verified. You do a great opportunity to big business for disbursing huge loan. 2 crore 27 lakh of public money.
What about the dealer?
Dealer, they are also fled
Where the money has gone?
Money was disbursed to the in the name of dealer from the bank directly.
Sir, so dealer is on,
Yes.
what is happened to him?
Dealer, my lord, what I understand from the dealer, the money has gone to the manager's wife's account. Manager's wife's account. Manager's wife's account.
Investigation is
And your lordship will kindly see one page. I have stated, my lord, the accused number one, branch manager, accused number two, they were both suspended by the authorities. Later on, my lord, accused number one was terminated. And the present accused number one, accused, my lord, he has been reinstated in service. And your lordship will kindly see page 28. Page 28. This is the bail order in respect of accused number one. And after the interim order, yes, so he is the main accused.
He is the branch manager.
So how this accused number two is involved? Accused number one, he has appeared before the police. He is now serving the bank. And this is the bail order in respect of accused number one. So I pray, my lord.
My lord, regarding my lord, he interim was given on 2nd of February, my lord. But
thereafter he went, he
yes.
appeared before the police.
My lord, that statement, my lord, I have not found, my lord. that statement is not.
Now, I think 12/3/2025, his bail was made absolute.
Yes.
Interim bail
Accused
was
number
made
one.
absolute.
Accused number one.
Accused number one.
Accused number one.
And as far as this person is concerned, interim protection was granted
On 2nd of February.
2nd of February.
Statements are section having to.
Thereafter, he went and gave his statements in the, before the police. So therefore,
Then I have to take a statement from the statement I have not found. I have charged up to 13 to all our witnesses.
and the bank, my lord, authorities, they have reinstated in service. Accused number one has been terminated. His role is processing, but disbursement from the whole thing has happened from the date of from the point of disbursement. The money came to the bank.
Mr. Parasar, you want to take the information?
He has appeared on, yes, CD is up to 13 to, but I have not.
So
found-
2/2/2/2, the order was there.
Maybe it is not there in the, but others, that court's order is also available regarding other persons, regarding his court's order also not available, regarding Himanshu Dhaka court's order is there,
14. My learned friend says he appeared on 14
of 14.
before the police.
Then up to 13 to it is there,
So we can take up in the second half, Mr. Das, let him take the confirmation whether he has appeared or not.
Yes, yes.
If he has appeared, then we'll consider the thing. After 2 o'clock, we'll take it.
Telephonically I'll take it.
Yes.
Item 40, hearing.
Before going for hearing of the case, Lordship, I is pending, Lordship.
Hmm?
I is for suspension of the sentence, Lordship. Already he has been behind the bar for 4 years. Sentence is for 5 years.
Food is already spent.
I is pending.
Oh,
Already spent 4 years.
You have already spent 4 years.
Yes. And I is also pending. There is a offense under section 8 of PROCEEDINGS Act. Lordship. Sexual assault.
Then it's better, the whole petition is
Yes,
disposed of.
yes, the entire
Already
case was
o-
under disposal, my lord.
Already 4 years he has spent.
Yes, no. That can be done. The impugned judgment is at page 31, Lordship.
1 second. Yes. Impugned judgment.
At page 31, starts from 33. Married.
Yes.
The prosecution case was set into motion by the SR dated 24/12/20, lodged by one Sri Brojan Gogoi before the officer in charge of Namti Police Station, stating entirely that their 13-year-old daughter, Miss So-and-so, had been lured by Sri Babul Das, the accused, to go to his house without their knowledge. On not seeing her for long, they asked their mason, and he told that Babul had taken away their daughter. Then the victim could be seen coming crying, and on being asked, she told that Babul Das had behaved indecently with her. It has been further alleged in the Azhar that the victim on earlier occasion also used to tell them that Babul Das used to give her bad signal, but they used to brush it aside, saying that he was joking. The case was registered under as Namti PS case number so-and-so under section 354A IPC read with section 8 of POCSO Act. Police started investigation, and on completion of investigation, submitted search sheet against the accused under section 354A IPC read with section 8 of POCSO Act. On appearance of the accused person and after furnishing him with the relevant copies, by order dated 18/2/2021,
charge was framed against the accused person under section 354A IPC, read with section 8 of the POCSO Act, to which he pleaded not guilty and claimed to be tried. Prosecution examined 6 members of witnesses, including the investigating officer. The statement of the accused had been recorded under section 13 of the CRPC. Defense adduced evidence of 2 witnesses. Defense plea was of denial. Hard argument advanced by the learned counsels of both the sides. Perused the evidence on record carefully. Points for determination. Whether the victim was a minor.
You need not read the whole judgment.
No, it starts from 33, Lord.
No. What I'm saying is that you are not required to read the whole judgment.
Yes.
So you'll have to show me what are the things, your grounds. And you come to the operative, a discussion of the learned trial court
Yes, sir.
and how trial court has come to the conclusion.
Okay. Page 37, Lordship, regarding PW1. Paragraph 9.
Yes,
During cross, PW1 stated that there were 6 to 7 residential houses near the house of accused.
PW1 is who?
PW1 is the informant, sorry, victim,
PW1 is victim. PW1 is victim. Yes.
That the elder daughter of the accused is her friend, and in that context, she used to visit their house. That she knows the persons residing there near the house of accused, but she does not know their actual names. That amongst them, she knows Sagar Das, Monu Das, Mitali Das, Nitumoni Gayan. Here only Sagar Das was examined. Monu Das, Mitali Das, Nitumoni Gayan, they were not examined. That she is aware about the family members of the accused as she used to visit their house. That in the house of Babul Das, his wife and 3 children, namely Meenakshi Das, Rupjoti Das, and Priyakti Das, who is her friend, reside. That the 3 children study in school. That on the date of incident, school was closed, and so the students of the school are in their respective homes. During the day of incident, school was closed, and students were also at home. That in the 6-7 residences near the house of accused, there were school-going children. That only when Babul Das told her that he is busy in some other work, she went inside their house, though she was not willing to go, as there was no one else in his house at that time. That the Tegari was in the last room of their new house, that there are 4 rooms in the new house of the accused, and there are 2 rooms in their old house. That the accused and his family used to reside in the old house, and in the new house, they did not reside. That the new house had been constructed adjacent to their old house. That in the new house, the construction of the walls were going on, including a room from where she brought the Tegari. That she shouted when the accused pushed her towards their bedroom, and the same was audible to Kobita Das. Kobita Das was also not examined. Kobita Das, that the incident was audible to Kobita Das.
Kobita Das not examined.
Not examined. Who used to reside nearby. That Kobita Das did not have any talking terms with her mother at that time, and she came out only when she shouted Ina Tiniali. PW1 during cross-examination further stated that she could know the seriousness of the offense committed upon her, that she did not state before the police as well as in the statement under section 164 CRPC, as well as during her in chief about Kobita Das. That it takes about 3 minutes by foot to go from their house to the house of the accused. That when she shouted in the Tiniali, about 15-16 persons assembled. That Kobita Das also came there. Kobita Das was very much there in the whole episode, according to the victim, but she was not examined. Next, you're looking at, kindly turn to page 39, next page. PW3, Sangita Gogoi, the mother of the victim. Paragraph 13.
Yes.
PW3 Srimati Sangita Gogoi is the mother of the victim, and she deposed in court that on 24/12/2020 at about 10:11 a.m. She was sleeping in her residence and her husband was at his workplace. That on that day, at about 5 a.m., she returned home from Gauhati, where she had gone for the purpose of her treatment. That besides her, her daughter Miss So-and-so and her son, aged about 5 years, were in her residence. That the mason, namely Lakhipura, on that day was working at her residence for constructing a gate at the entrance of her residence. that when she was sleeping, she woke up on hearing hue and cry. That her daughter, Miss X came crying to her and told that Lokibora was searching for the Tegari, but he did not find the same. That her daughter told that along with Lokibora, accused Babuldas also came and asked her to go with him to his house to bring the Tegari. The Lokibora was the mason in their house, and he asked Babuldas to bring the Tegari and send this victim along with Babuldas.
No, it is not. Her daughter told that along with Lokhi Bora, accused Babul Bora also came and asked her to go to his home to
Asked,
bring that away.
asked her to go to Babuldas' home to bring the Tegari.
Babul Das is having a tagari, so he asked
Yes,
that
yes.
the daughter to go there and bring it.
Yes. That her daughter told her that she accordingly went with the accused Babuldas to his house. That her daughter further told her that the accused asked her to go inside his house for bringing the Tegari, and when she went inside his house, the accused grabbed her breast and attempted to disrobe her by removing her clothes. Here it is 164 statement. PW3 never disclosed that this sentence. When she went inside his house, the accused gave her breast and attempted to disrobe her by removing her clothes. That she further told her that the accused dragged her towards his bedroom. That her daughter also told her that she then started crying and pushed the accused with the Tegari and somehow escaped from there. So, next at page 41, PW2. Paragraph 18.
The accused worked as a helper,
Helper of the mason.
mason.
Mason is Lokibora, and he was working as helper.
PW2.
PW2 is the father of the victim. Paragraph 18.
Paragraph 16.
No, I'm reading paragraph 18 first.
Okay.
Page 41. PW2 admitted not to have stated before the investigating officer and his statement under section 164 CRPC that accused told him that he was joking with his daughter. PW2 during cross stated that before the incident, his wife told him that Babuldas used to commit misdeed with their daughter. PW2 during cross denied suggestion that even after knowing about the accused, he engaged him in the works of his house. PW2 during cross stated that accused worked in his house for 2 days before the date of incident. That his daughter was a friend of the daughter of the accused, and although they had visiting terms, but after coming to know about the misdeed of the accused, he did not allow his daughter to go to the house of the accused. That he did not see Babuldas coming to their house on the date of incident. That Babuldas used to reside at a distance of 200 meters from their house. That he know the neighbors of the accused. That there are 2 residential house near the house of the accused, namely his brother Rubuldas and his mother Guneswaridas. They were also not examined. That in between their house and the residence of accused, there are 3 residential houses. That when he went to the house of accused, he did not find any of his neighbors and no one asked him about the incident. Learned counsel for the accused submitted that there is contradiction in the evidence of the victim made before the court as PW1 with her statement made there under section 164 CRPC. Learned counsel for the defense pointed out that in her evidence before court, the victim as PW1 stated that she assaulted the accused with the dagger in his shoulder. Whereas in her statement under section 164 CRPC, the victim stated that she assaulted the accused in his neck. Learned counsel for the accused further submitted that as per the evidence of the victim PW1, after the incident, she came out and reported the incident to Sri Sagardas. She reported the incident to Sagardas, but Sagardas, Mitali Das and Srimati Monu Das and Nitumani Gayam. Only Sagardas was examined. These other 3 persons, Mitali Das, Srimati Monu Das and Nitumani Gayam, they were not examined. But prosecution only examined Sri Sagardas as witness, which creates doubt in the case of the prosecution. Learned counsel for the accused also submitted that on the date of incident, the victim went to the house of the accused in search of the Tegari with her younger brother. And at the time of incident, the 3 children of the accused were playing in the courtyard of the house of the accused. Learned counsel for the accused accordingly submitted that the case of the prosecution is totally false and concocted.
So there is no eyewitness.
No, there was no eyewitness.
Hmm.
Next, Your Lordship, at page 48, the Lakhipura Mason, PW5,
Is,
48, paragraph 27.
yes,
PW5, Sri Lakhipura deposed in court that on the date of incident, he was engaged in the construction of gate in the house of Projan Gogoi as told by Babul Das. That on the date of incident, when he was engaged in work, he was in need of tegari. And the accused who was passing by at that time, here it is stated that he was passing by, the accused was passing by, not working as a helper. At that time, told that the tegari was in his house. That he then sent the daughter of the informant to collect the tegari from the house of the accused, and she accordingly went there, but did not bring the tegari. That after some time, he saw the victim inside their house and asked her about the tegari, but she did not reply anything. That after about 1 hour, mother of the victim told him that something had happened with her daughter and that she had to return home crying. That mother of the victim told him that accused had caught her daughter and so she returned home crying.
Hmm.
During cross of PW5 stated that on the date of incident, the victim went with her younger brother to the house of the accused to bring the tegari. That he did not see the victim coming out from the house of the accused. That the victim did not tell him about the incident. Here, the PW5 stated that she was accompanied by her younger brother. Whereas the prosecution case is that she was alone.
Hmm.
At page 49, paragraph 30, DW1 and DW2,
Hmm.
DW1
Hmm.
and DW2, the daughters of the accused. Srimati Piakshi Das and Srimati Meenakshi Das are the daughters of the accused.
You said these people are not examined. Who were there? Not examined. Who were there?
No, that they were neighbors. They were neighbors.
Sagar and other people,
Sagar Das was examined.
and other people who were there.
Other people were not examined.
Who are the name? What are the names?
They were Mitali Das, Monu Das, Nitumoni Gayan.
Okay.
Mitali Das was one, Mitali Das, and one Kavita Das was also there, whom
Hmm.
she reported that.
She heard, but like she did not did not come out for any help.
Yes,
Hmm.
and even she reported to Kavita Das.
Hmm. No, she didn't say reporting.
No.
I think she said in the Tiniali, when she shouted, then she came, and she was also there. She did not say she reported. Let's carry on. Paste para 30.
Page paragraph 30. DW1 and DW2, Srimati Piakshi Das and Srimati Meenakshi Das are the daughters of the accused, and as per their evidence, at the time of incident, they along with their younger brother were playing in their front courtyard, and that the victim and her brother were also playing with them. DW1 and DW2 deposed in court that the victim came to take the tegari from their house and that their father then told the victim to take the tegari and scolded her as she was playing and he was getting late for market. As for the evidence of DW1 and DW2, their father took out the tegari from inside their house and handed over the same to the victim in front of their house, and thereafter she went away. Paragraph 31.
Hmm.
Now, except PW5 Sri Lakhipura, none of the other witnesses examined by prosecution deposed before the court that on the date of incident, the younger brother of the victim also accompanied her to the house of the accused to bring the tegari. Because none of the witnesses stated that she was not accompanied by her brother, only Lakhipura, the Mason, stated, the PW5. That's why court held that, no, it was not, held that she was alone during the time of incident. 313 statement, your lordship will find at page 49A. Internal.
So
page
these are the witnesses?
Yes, these are only, what Sagodas is there.
Where is his deposition?
Annex of 5, page 21.
Page 21. Page 21, where? His PW?
PW 5, 4.
PW4, where is that PW4 statement?
My name is Sagodas.
No, where? Page
Page 21. Annex of 5.
21, okay. No, there is no discussion.
The discussion is there.
Where? Just show me once what has been discussed about him.
At page 47.
Yes, where?
This is
47,
the finding.
more as his deposition must have been discussed somewhere. Para 25.
As per the evidence of PW1, the victim, when she came out running from the house of the accused, she met Sagodas, and on being asked by him, she reported to him the incident. Sri Sagodas has been examined as PW4, and he deposed in court that on the date of incident at about 9 a.m., he was doing household work in front of his house. And at that time, the victim came out of her residence and addressed him as Botta and went to the house of the accused. That after about 3 to 4 minutes, he heard hue and cry of victim from the house of the accused. That when he reached in front of the house of the accused, he saw the victim crying in the courtyard of Babuldas. That on being asked by him, the victim told that the accused had grabbed her breast. During cross, PW4 said that the house of the informant is about 100 meters from his house. That when the victim went to the house of the accused, crossing his house, at that time, Milon and Khitik were also present with him. PW4 during cross stated that he has no good terms with Babuldas since quite some time. That he has good terms with informant Broden Gogoi and had come to the court with him. This Milon and Khitik, they were also them as well.
Miller and Khitik not examined.
No. 6 witnesses were examined, including the IO.
Yes. Okay, then come to the conclusion part.
At page 49B, internal page 21. Now, I would like to refer to a decision of Honorable Supreme Court in case of so-and-so, wherein Honorable Supreme Court discussed thus. It is a well-known principle of law that reliance can be placed on the solitary statement of a witness if the court comes to the conclusion that the state statement is the true and correct version of the case of the prosecution. The courts are concerned with the merit and statement of a particular witness and not at all concerned with the number of witnesses examined by the prosecution. The time-honored rule of appreciating evidence is that it has to be weighed and not counted. The law of evidence does not require any particular number of witnesses to be examined in proof of a given fact. However, where the court finds that the testimony of solitary witness is neither wholly reliable nor wholly unreliable, it may, in given sets of facts, seek corroboration, but to disbelieve reliable testimony of a solitary witness on the ground that others have not been examined is to do complete injustice to the prosecution. In our case in hand, as discussed, the evidence of the victim PW1 has been corroborated by the evidence of our father and mother, PW2 and PW3. The case of the prosecution is also supported by Sri Sagardas and also to some extent by Sri Lokhi Bora. As discussed, the pleas taken by defense being inconsistent cannot be believed and the same as such lends credence to the case of prosecution. As pointed by defense, there are certain contradictions and omissions on the part of the witnesses, but the same are found to be minor only. The statements made before the court by the witnesses as PW1, PW2, and 3 are not found contradictory to their previous statements made under Section 161 CRPC and Section 164 CRPC. From overall totality of their evidence, it can be assumed that our evidence does not suffer from any sort of discrepancy so as to disbelieve the same. As held by the Honorable Supreme Court in case of Sahabuddin versus State of Assam, this is a settled principle of law that while appreciating the evidence, the court must examine the evidence in its entirety upon reading the statement of a witness as a whole. And if the court finds the statement to be truthful and worthy of credence, then every variation of or discrepancy, particularly which is immaterial and does not affect the root of the case of the prosecution, would be no consequence. Now, the present case is under the Protection of Children from Sexual Offences Act, and this was enacted with the objective that children of tender age are not abused, and their childhood and youth are protected against exploitation, and they are given facilities to develop in a healthy manner and in conditions of freedom and dignity. The aims and object of the Act for the considered is imperative.
So let's go to evidence part.
In findings.
No, I mean, have you, you have no annexed, no, the
Yes,
deposition,
I have an example.
depositions?
Yes,
Where?
it starts from page 14.
First, let us see the FIR, what has been written in that.
Particular at page 13 and type copy is at page 10.
13.
13 is the particular. সন্মান সহকাৰে আপোনাক জনাও যে আমাৰ ছোৱালী আস্থা বয়স 13 বছৰ ওচৰৰ বাবুল দাস নামৰ এজন মানুহে প্ৰলোভন দি তেওঁৰ ঘৰলৈ লৈ যায় আমাৰ অজ্ঞাতে পাছত আমি বহু সময় তাইক নেদেখি আমাৰ ঘৰৰ মিস্ত্ৰীজনৰ কথাত মিস্ত্ৰীজনে বাবুলে তাইক লৈ যোৱাৰ কথা কয় তেতিয়া তাই দৌৰি দৌৰি কান্দি কান্দি আহি থকা আমি দেখো আৰু তাই কি হ'ল বুলি সোধাত তাই বাবুলে তাইক বেয়া ব্যৱহাৰ কৰিবলৈ লোৱা কথা কয় আৰু তাই ইয়াৰ পূৰ্বেও ই কেইবাদিনো তাইক বেয়া ইংগিত দিছিল বুলি আমাৰ আগত কৈছিল যদিও আমি কথাটো পাতল কৰি ৰাখিছিলো মালিক কৰিছে বুলি ভাবি কিন্তু আজি আমাৰ অজ্ঞাতে যেতিয়া পুনৰ এই ঘটনাৰ পুনৰাবৃত্তি ঘটাত উক্ত বিষয় সন্দৰ্ভত আমি আইনৰ কাষ চাবলৈ বাধ্য হৈছো
This filed on 24/12.
24/12/20.
Okay.
Evidence of PW1 is at page 14. Next. Married.
Yes.
My date of birth is 28/11/2006. Informant is my father. The Azahar has laws against Babul Das. I know the accused as he is my neighbor. He is my father's friend and I used to address him as Kura. Incident took place on 24/10/2020. Before the day of incident, my mother went to Gauhati for medical treatment. On the date of incident at about 9:10 a.m., my mother, after returning home from Gauhati, was taking rest. My father also went out for business work. On that day, masons were constructing the front gate of our house and was constructing the post of the gate. Mason Lokibora alone was constructing the post. Lokibora then came to our house and sought for the tegari, article used in construction. Our tegari was in the house of the accused as they had taken it beforehand. The mason asked me to bring the tegari from there. The accused also heard the mason telling me to bring the tegari from their house, and he also asked me to come to his house for the tegari. I did not want to go, but at the same time could not tell the reason to the mason that on earlier occasions also accused used to come to our house and used to leave my wearing skirts. At first, I thought he was joking with me, but on the second day, he also repeated the same. At first, when I told my mother about the accused, my mother also thought it a joke. But after the second time, my mother also became cautious, and my parents, after that, did not leave me alone in the house. Hesitantly, I went to the house of accused. On the date of incident, when I went in search of the tegari, and after reaching their courtyard, I asked the accused to bring out the tegari. The accused, however, asked me to go inside their house and bring the tegari myself. At first, I refused to enter inside their house, as no one else was present, but he insisted on me going inside by telling me that he is busy in other works. I then entered inside the house of accused to bring the tegari, and the accused also followed me and catching hold of me in my shoulders, pushed me towards the bedroom. The accused then placed his hands over my breast, over my clothes, and tried to open my sporting. At that time, I was wearing a yellow-colored sporting and a 3/4 pant. and then assaulted the accused with the dagger.
Tegari was in the new house, right? Newly
Yes.
constructed house.
Newly constructed house. At that time, I was wearing a yellow colored sporting and three-quarter pant. I then assaulted the accused with the dagger in her shoulder and came out running. I raised hue and cry in front of his house in the nearly. Sri Sagardas then came out and asked as to why I was shouting, and then I told him about the incident. My aunt Mitali Das, Srimati Monu Das, Nitu Monigayan also came out hearing me crying, and I reported them about the incident. She reported to Mitali Das, all of them.
Hmm?
He reported the incident to all of them. Mitali Das, Monu Das, Nitu Monigayan.
Yes,
to
not
all-
Kavita Das.
Yes, not Kavita Das. They told me to go home and report the incident to my elders, and I accordingly came home and reported my mother about the incident. Myself and my mother went to the Tiniali in front of the house of accused, and we assaulted him in the Tiniali. The accused then told that he simply pushed me and did not do anything. My mother then informed my father about the incident. After my father came, we went to the police station. My father, before going to the police station, went to the house of accused to ask him about the incident, but the accused refused to admit and asked my father to do whatever he likes. My father then lost the other. Police interrogated me about the incident and took me to hospital for medical examination and also brought me to court for recording my statement under section 164 CRPC. Cross-examination by defense. There are 6 to 7 residential houses near the house of accused. The elder daughter of the accused is my friend, and in that context, I used to visit their house. And so I know the persons residing near the house of accused, but I did not know their actual names. Among them, I know Sagar Das, Monu Das, Mitali Das, Nitu Monigayan. I am aware about the family members of the accused as I used to visit their house. In the house of Babul Das, his wife and his 3 children, namely Meenakshi Das, Rukjuri Das, and Priyakhi Das, who is my friend. The 3 children study in school. On the date of incident, school was closed, and so the students of the school were in their respective homes. In the 6-7 residential houses near the house of accused, there are school-going children. Only when Babul Das told me that he is busy in some other works, I went inside their house, and though I was not willing to go, as there was no one else in his house at that time, the Tegari was in the last room of their new house. There are 4 rooms in the new house of the accused, and there are 2 rooms in their old house. The accused and his family used to reside in the old house. The new house, they did not reside. The new house had been constructed adjacent to their old house. In the new house, the construction of the walls were going on, including the room from where I brought the Tegari. I shouted when the accused pushed me towards their bedroom, and the same was audible to Kavita Das, who used to reside nearby. Kavita Das did not have any talking terms with my mother at the time, and she came out only when I shouted in the Tiniali. I could know the seriousness of the offense committed upon me. I did not state before the police as well as in statement under section 164 CRPC, as well as during the incident about Kavita Das. It takes about 3 minutes by foot to go from our house to the house of the accused. When I shouted in the Tiniali, about 15 to 16 persons assembled. Kavita Das also came there. It's not a fact that I did not state before the IO and in Exhibit 1 that when I raised hue and cry in the Tiniali, about 15, 16 persons assembled. It is not a fact that I did not state before the IO and in Exhibit 1 that I reported to my mother on 2 occasions that accused used to commit misdeed with me, that the accused tried to lift my wearing clothes. I did not state before the IO that I assaulted the accused with the Tegari as police did not ask me in detail about the incident. It is not a fact that the wife and children of the accused were present in their house at the time of incident. It is not a fact that no incident as narrated by me had taken place. It is not a fact that only on being instigated by my mother, I have deposed against the accused.
Okay, we'll take, we'll continue after.
Lord. Wait, please, Your Lordship. Lordship, I beg to mention item number 34. It's an anticipatory bail matter. The matter has become infructuous because the applicant has already been arrested.
Already been
Arrested,
item number 34.
my lord. Matter may be disposed of on withdrawal.
Item number 34, you see? 6-3. Okay, then you write 6-3, you modify the order. You write that you are Mr.
R Ghosh.
R. Ghosh, you are for the petitioner.
Yes,
R. Ghosh, learned counsel appearing to the accused applicant. I also heard Mr. R.J. Bora, learned APV for the state. This is an application under so and so you write. Then you write that Mr. Ghosh submits that the present accused applicant has already been arrested in the instant case, and therefore the present AB application and this would bail application has become infractuous. Full stop. In view of the aforesaid, the instant anticipatory bail application is dismissed.
Obligement.
May I please mention, I beg to mention item number 35, Lordship. As for instruction of the petitioner, Lordship, withdraw this matter, Lordship.
Withdraw.
Withdraw, yes.
35.
That it's
Okay. Mr. Then 35 you write. Mr. A. Datta, the learned counsel appearing for the accused applicant submits that he has instruction to withdraw the instant. A bail application.
Yes, AB, Lordship.
Withdraw the instant AB application where is allowed. The instant AB application is dismissed on withdrawal.
And liberty may be granted, Lordship.
Yeah, that you always have the liberty.
Liberty, please. No,
You-
please, Lordship, liberty.
You always have the liberty, Mr. Doctor. You don't keep on insisting on certain things which is not required. You always have a liberty. You can always file as many bail applications you want. Is it required to be given by the court? You have been practicing for these bail applications. You have been appearing in this court for such a long time. Why liberty is required?
At least we file again as per.
See, Mr. Datta, don't keep on something which usually the court doesn't give. There is no need of this. I mean, once bail is rejected, you can always come for a different bail. There is no bar. Is there any bar? Then no, when you sit again. In view of the aforesaid discussions and findings of this court is of the considered opinion that the instant criminal revision petition should be allowed on the aforesaid ground alone and should be remanded to the learned session judge Tinsukia to consider and hear the criminal appeal number so and so afresh without taking into consideration the judgment and order dated 34/2011, which has already been set aside by the learned session judge Tinsukia by its order dated 1/11/2011. Accordingly, it is directed that the learned session judge Tinsukia shall hear the criminal appeal number 11 in bracket 2/2011 on its own merit and decide the same within a period of 2 months from the passing of this order, as the case relates back to an FIR lodged in 2007. So it is disposed of. It is remanded.
45.
Bail application is rejected.
46.
Bail application allowed.
47.
Interim order made absolute.
Apply.
48.
Rejected.
9.
Allowed.
50.
50 also allowed.
Deeply applied.
51.
Allowed.
Lordship, I beg indulgence regarding mentioning item 42, Lordship. May I take up this matters next week, Lordship? I'm not feeling well.
Okay, on the prayer of the learned counsel, appearing to the you,
And
40,
for the petitioner, Lordship,
for the petitioner,
42 item.
let the matter be listed in the next week.
31 malat, I have talked with the IO malat, till 31, 13 malat, we have received the CD, but he has not appeared malat. Malat, he has not appeared. Now, if again want to appear malat, but as far as
allow time to, he has appeared on the his statement was recorded. Not recorded, statement was taken verbally. That's what my client said. But he will appear.
so malat, for updating the CD malat, his statement is necessary malat. On that
Heard
matter,
Mr. B.D. Das, the learned senior counsel, assisted by Mr. S. Bora, the learned counsel for the accused applicant, also heard Mr. K.K. Parasar, the learned additional PP for the state. Mr. Das submits that in terms of the order dated 2/2/2026, the accused applicant appeared before the IO, however, his statement could not be recorded. In view of the aforesaid, he submits that the interim protection given to him by order dated 2/2/2026 may be extended for some period so that he can appear before the IO and get his statements recorded. The updated case diary in the instant case to be produced before this court. And it is directed that the interim protection granted by order dated 2/2/2026 is extended for another period of 7 days from passing of this instant order. The accused applicant shall appear before the IO within the aforesaid period.
Yes, and his statements will be recorded. That may be.
malat,
Otherwise, they do not record.
I will inform.
And his his statement should be, and his statement shall be recorded by the IO.
Malat,
Release the matter on
17th of March.
17th of March.
Number 40.
Yes, where are we?
Now-
Where
Now,
were we?
now PW2,
PW2
Father-
is paid.
page 17. Father of the victim and the informant. I am the informant of this case.
1 second. 1 second. Yes,
I am the informant of this case. Victim is my elder daughter. I know the accused as my neighbor. My daughter was born on 28/11/2006. I have brought the original birth certificate of my daughter with me to court. Exhibit 2 is the birth certificate. I lost the other regarding the incident on 24/10/12/2020. On that day, I was out of house in connection with business. On that day at about 10 a.m., my wife told me that an incident had taken place in our house and asked me to come home. Immediately I came home and saw my daughter Asthajita Gogoi crying. My wife then told me that she was taking rest in house and the mason Loki Bora, who was constructing the pillar of our gate, asked my daughter to bring the tegari from the house of the accused. My wife then told me that my daughter went to bring the tegari when the accused pushed her towards their bedroom and put his hands underneath her clothes and also lifted her wearing clothes. My wife told me that she went to the house of accused to ask about the incident, but he refused to admit. On being told by my wife, I went to the house of accused and asked him about the incident, but the accused told me that he was only joking with my daughter. The accused refused to admit and asked me to do whatever I can do. I then went to the police station and lodged the Azhar. Exhibit 3 is the Azhar and Exhibit 3-1 is my signature. Police interrogated me about the incident and also brought me to court for recording my statement under Section 164 CRPC. Exhibit 4 is my said statement and Exhibit 4-1, 4-2 are my signatures. Exhibit 5 is the cigarette list, which the birth certificate of my daughter was seized. And exhibit
Yes, skip it, cross-examination.
cross-examination. It is not a fact that I did not state before the IO and in Exhibit 4 that on being told by my wife, I went to the house of the accused person, that the accused put his hands below the wearing cloth of my daughter. I did not state before the IO and in Exhibit 4 that accused told me that he
One
was-
second. Mr. Chaudhary, I mean, you are appearing, you are waiting for that matter. There was a bail hearing, right? Then you can come after some time. I mean, it will take some time. Or we can fix it in the next week if you want. Item number 6, huh? Item number 6 is right. Mr. NNB Chaudhary, Lalani Council, Mr. NNB Chaudhary. For the you are for the petitioner, right? You are for the, for the accused applicant is present. Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General is also present for the respondent. On the prayer, on the joint prayer of the council, preparing for the parties, let the matter be fixed on 11th of March. Any, it's a bail, right?
Bail, madam.
Your Lordship, I am item number 42. Just now I came to know that the petitioner has taken the time and the honorable court has fixed for the next week. May the
42.
42 fixed date may be given, Your Lordship. Just now, I did it. Just now I came to know.
Oh, hearing to it. Yes, what do you want?
Fixed date may be given. If it is next week, it will be either
Okay, you give a fixed date. I mean, you make it, next week, I mean, okay, we fix it on 12th. 12th. You just intimate him.
Your Lordship.
You intimate the lawyer, other side counsel.
12th.
Fixed on 12th.
But I get to submit item 41, bail, appeal hearing, madam. A fresh case, madam. So it did come on after first week of April.
First week of?
April,
Why so much? It's a hearing matter.
hearing.
I
I
mean,
the first time it has come.
and for which year? From which year?
41, I think.
Huh? 23,
23, madam.
23. Okay, on the prayer of the learned, on the prayer of Mr. S.C. Biswas, the learned counsel appearing for the appellant.
Yes.
Appellant, let the matter be fixed in the first week of April. You please, who is the, from the state only state? Okay. List of the first week of April.
Trial court record already received.
Yes.
First week of April. TCS so received to be retained. Yes.
I did not state before the IO and in Exhibit 4 that accused told me that he was joking with my daughter. Before the incident, my wife told me that Babuldas used to commit misdeed with my daughter. It is not a fact that even after knowing about the accused, I engaged him in the works of my house. Accused worked in my house for 2 days before the date of incident. My daughter was a friend of the daughter of the accused, and although they had visiting terms, but after coming to know about the misdeed of the accused, I did not allow my daughter to go to the house of the accused. I did not see Babuldas coming to our house on the date of incident. Babuldas reside at a distance of 200 meters from our house. I know the neighbors of the accused. There are 2 residential houses near the house of the accused, namely his brother Rubuldas and his mother Gunaswari Das. In between our house and the residence of accused, there are 3 residential houses. When I went to the house of the accused, I did not find any of his neighbors and no one asked me about the incident. It is not a fact that no incident as alleged had taken place and that I have lost the case only on being instigated by my wife. I did not witness the incident personally.
Yes, carry on.
Next, PW3, mother of the victim. Informant Pradhan Gogoi is my husband. Victim Astharita Gogoi is my daughter. She is presently about 15 years of age. The incident took place with my daughter, for which my husband had lost the other. Accused Babuldas is known to me being my neighbor. On 24/12/20, at about 5 a.m., I returned home from Gauhati, where I had gone for the purpose of my treatment. The incident took place at about 10:11 a.m. on 24/12/2020. At that time, I was living in my residence and my husband was at his workplace in the market. Besides me, my daughter Astarita Gugoi and my son Vedanta Gugoi, aged about 5 years, were at my residence. A mason, namely Rafi Bora, was working on the day at my residence for building a gate on the entrance of my residence. While I was sleeping, I heard hue and cry, hearing which I woke up. My daughter Astarita Gugoi came crying to me and told me that Rafi Bora was searching for the Tegari, but he did not find the same. He also told me that along with Rafi Bora, accused Bubuldas also came and he asked her to go with him at his house to bring Tegari. She told me further that she accordingly went with the accused Babuldas to his house. She also told me that the accused Babuldas asked her to go inside his house for bringing Tegari, and when she went inside his house,
Okay,
accused
okay.
Babuldas grabbed her breast and attempted to disrobe her by removing her clothes. She further told me that the accused Babuldas dragged her towards his bedroom. She also told me that she then started crying and she pushed the accused with the Tegari and somehow escaped from there. After coming to know about the aforesaid incident from my daughter, I called up my husband over phone and he came back to our residence after about 1 hour. When my husband went to the accused at his house to know what had happened, the accused expressed to him to do whatever he wants.
Okay, skip over.
Cross by defense. Accused Babuldas is known to us since long time. Till the day of occurrence, we and accused Babuldas used to visit each other's house, and there was cordial relation between us till the date of incident.
Yes.
Accused Babuldas worked as helper.
So there was no enmity.
Yes, there was no enmity.
So that there should not be any false allegations against
But
him.
in his chief, he has stated that there was enmity, so he refused to send his daughter to his house.
Who said?
In chief, PW2, father of the victim. Father of the victim stated that. In cross-examination, page 18. Before the incident, my wife told me that Babuldas used to copy
One
pieces.
second, one second. No, he's talking about after the incident.
No, Rosif.
After the incident, my daughter was a friend of so-and-so, although they had visiting terms, but after coming to know about the misdeed of the accused, I did not allow. So he may be referring to the incident, after the incident. Yes, come.
Used to visit each other's house and there was cordial relation between us. Accused Babuldas worked as helper with Mason Loki Bora while constructing the gate at the entrance of our house. I did not state before police that the accused attempted to disrobe my daughter by removing her clothes. I did not state before police that hearing him and cry, I woke up. It is to the fact that no incident ever took place as stated by me today in my examination in chief.
Yes.
Next, PW4, Sagodas. I know informant Bojan Gogoi and her daughter Astarita Gogoi. I know accused Babuldas. They all are my neighbors. The incident took place about 1.5 years back from today. At about 9 a.m., I was doing household works at the front side of my house. At that time, Astarita Gogoi came out from her residence and addressed me as Borta, and then she went to the residence of accused Babuldas. After about 3-4 minutes, I heard he went cry of Astarita from the house of Babuldas. While I reached in front of the house of the accused Babul Das, I saw Astarita in the courtyard of Babul Das. She was crying. When I asked her what happened, she told me that the accused Babul Das had grabbed her breast. Police recorded my statement. In between my house and the house of the accused Babul Das, there is the house of my elder brother Tularam Das. I have no good terms with Babul Das since quite some time. So it is.
No, that doesn't mean that like it's only because there is no good terms. Anyways, I mean, you have pointed out something, but
Paragraph, page 22.
Hmm.
Next page. Apart from the house of Babul Das, there are as many as 5 houses adjacent to one another. House of informant Bojan Gogoi is about 100 meters away from my house. While Astarita went to the house of accused Babul Das, crossing my house, at that time Milon and Khitik were also present alongside me. It is not a fact that I did not state before police that at that time Astarita Gogoi came out from her residence and addressed me as Botta, and then she went to the residence of accused Babul Das. It is not a fact that I did not state before police that while I reached in front of the house of the accused Babul Das, I saw Astarita in the courtyard of Babul Das and that she was crying, and that when I asked her what had happened, she told me that the accused Babul Das had grabbed her breast. I have good terms with the informant Bojan Gogoi. Today I have come to the court with Bojan Gogoi. It is not a fact that I have deposed today as tutor to me by the informant Bojan Gogoi. Next, PW5, the Mason, Noki Bora. He is a vital witness because he sent her to bring the Tegari. Married.
yes,
I know the informant. I also know the victim girl. I know the accused Babul Das. The incident took place in February 2020. On the date of incident, I was engaged in construction of gate in the house of Bojan Gogoi as told by Babul Das. I used to work with the accused as his mason. On the date of incident, when I was engaged in work, I was in need of Tegari, and the accused who was passing it by at that time told me that the Tegari was in his house. I then sent the daughter of Bojan to collect the Tegari from the house of the accused. She accordingly went to the house of the accused, but did not bring the Tegari. After some time, I saw the victim inside their house and asked her about the Tegari, but she did not reply anything. After about 1 hour, mother of the victim told me that something had happened with her daughter and she had to return home crying. Mother of the victim told me that the accused had caught her daughter and so she returned home crying. Police interrogated me about the incident after the case was lost. Police also sent me to court for recording of statement under so and so. Cross by defense. On the date of the incident, the victim went with her younger brother to the house of the accused to bring the Tegari. I did not see the victim coming out from the house of the accused. The victim did not tell me about the incident. I did not see the victim crying. He's the mason working there in victim's house, and he sent the victim to bring the Tegari. Next, PW6, the informant, the IO. On 24/12/20, I was posted as ATAS officer at Nam TPS. On that day, I was on leave. On that day, on the other lost by informant Bojan Gogoi, after registration of the case, the OC entrusted the investigation of the case to ASI Ashok Ganguly. He interrogated the informant and recorded his statement and also the statement of the driver. Also recorded the statement of the victim at the PS. Medical examination of the victim was not done as the informant had given in writing that his daughter does not want to undergo medical test as she has not sustained any injury. ASI Ashok Ganguly visited the PO and prepared the sketch map and recorded the statement of the two witnesses. On the next day, the accused was apprehended in his residence and he was brought to the PS. The birth certificate of the victim was seized. The victim, along with more witnesses, were forwarded to the court to record their statement under section 164 of CRPC. Thereafter, took up the investigation, completion of the incident as available. Asus Ganguly, I can identify. Exhibit 8 is the sketch map, but the names they are in the sketch map. The persons whose houses were shown in the sketch map, they were not examined. Proof by defense. The time of incident has not been mentioned in the other and the printed form of FIR. The medical of the victim was not done because of the unwillingness on the part of the informant. Statement of the persons whose names are mentioned in the sketch map have not been examined. The statement of Sagar Das has been recorded. However, the statement of Monu Das, Mitali Das, Nitu Monigan have not been recorded. In the sketch map, 3 residential houses are shown. The statement of Kavita Das has not been recorded. The statement of the persons whom the victim have claimed to have met on her way to the linearly have not been examined. The victim in her statement under section 161 of PRPC stated that on earlier occasions also, the accused gave her signal of misdeed. However, she had not stated that on earlier occasions, the accused committed misdeed. Only about signals, not committing misdeed. PW1 Astarita Gogoi did not state before me that I reported to my mother on 2 occasions that the accused used to commit misdeed with me. That the accused tried to leave my wearing clothes. PW2 Brozen Gogoi did not state before me that the accused put his hand below the wearing clothes of my daughter. Brozen Gogoi before the IO told the time of incident as 10 a.m. PW3 Sangita Gogoi stated before the IO the time of incident as 10 a.m. PW3 stated before the IO that the accused put his hand on the breast and the back of her daughter. PW3, however, did not state about the opening of clothes. PW3 did not state before the IO that Babul Das was working in their house as mason. PW3 did not state before the IO that when the victim raised hue and cry, she woke up. PW4 Sagar Das did not state before me that at that time, Astarita Gogoi came out from her residence and addressed her Borda and then went to the residence of accused Babul Das. That after 3-5 minutes, she heard the cry of Astarita Gogoi from the house of Babul Das.
Yes.
PW4, Sagardas further did not state before me that page 28,
Hmm?
reading the statement of IO at page 28.
Medical statement.
No, IO.
IOS.
There was no medical statement because he refused.
IO, anything you want to show in IO statement?
Here also, something what has not been stated in under section 161 has come to light in these depositions.
161, 164.
164 statement.
Hmm?
164 statement. What
Hmm.
has not been stated in the 164 statement that has come over here.
There as come as what?
There is contradiction. There is no
164 by whom? 164 by
the
IO.
victim as well as all the witnesses. Even by the informant.
Hmm. Okay, come to DW1.
Priyaksi Das, accused Babul Das is my father. Victim Astajita Gogo is my classmate. It takes about 10 minutes by foot to go to the house of the victim. The incident took place about 2 years back at about 9 to 10 a.m. Astajita went with her younger brother. She came to take the Tegari from our house. Me and my younger brother and sister were playing in our front courtyard. Astajita and her brother were also playing with us. My father then told Astajita to take out the Tegari and scolded her as she was playing and he was getting late for market. My father then took out the Tegari from inside our house and handed over the Tegari to Astajita in front of our house. Thereafter, she went away. Our school was closed on that day. Cross-examination. It is not a fact that on the date of incident we were not at home. It is not a fact that I have stated falsely that on the date of incident me and my younger brother and sister were playing in our front courtyards and that Astajita also played with us. It is not a fact that on the date of incident my father sent Astajita to inside our house to take the Tegari. It is not a fact that for the sake of my father I have testified falsely before the court today. Next, DW2. Meenakshi Das. Accused Babul Das is my father. Victim Astajita is the classmate of my sister. The incident took place about 2 years back at about 9 to 10 a.m. Astajita went with her younger brother. She came to take the Tegari from our house. Me and my younger brother and sister were playing in our front courtyard. Astajita along with my father and her younger brother came to our house. Astajita and her brother also played with us. My father then told Astajita to take out the Tegari and scolded her as he was playing and he was getting late for market. My father then took out the Tegari from inside our house and handed over the Tegari to Astajita in front of our house. Thereafter, she went away. Our school was closed on that day. Before the incident, we had visiting terms with the family of Astajita. Prohibitions by Proceedings. It is not a fact that on the date of incident, Astajita did not go with her younger brother to our house. It is not a fact that on the date of incident, Astajita went only with her father to our house. It is not a fact that on the date of incident, we were not at home. It is not a fact that I have stated falsely that on the date of incident, me and my younger brother and sister were playing in our front courtyard and that Astajita also played with us. It is not a fact that on the date of incident, my father sent Astajita inside our house to take the Tegari. It is not a fact that for the sake of my father, I have testified falsely before the court today. These two witnesses were not considered at all.
Hmm?
These detailed views were not considered at all. Well, confirmed with my plan.
Not considered.
Yes,
DW.
it will be 1 and 2.
Have you annexed 313? 313 statements, have you annexed?
No, there is not a next. In Shivan's statement, he just stated that he pushed her only.
Hmm?
Sorry, at page 49A, your lordship will find the finding recording of the trial court at page 49A, internal page 20.
Page 40.
49A, internal page 20. In the mid of the paragraph, whereas the accused during his examination under section 313 CRPC stated that he told the victim to bring out the tegari herself and that the victim went out with the tegari to her own house. This much is. Regarding DW and DW2 at page 49, paragraph 30. DW1, DW2, Srimati Piyakshi Das and Srimati Meenakshi Das are the daughters of the accused and as per their evidence at the time of incident, they along with their younger brother were playing in their front courtyard and that the victim and her brother were also playing with them. DW1 and DW2 deposed in the court that the victim can take the tegari from their house and that their father then told the victim to take out the tegari and scolded her as she was playing and he was getting there from market. After the evidence of DW and 1 and 2, their father took out the tegari from their house and another brother sent to the victim in front of their house and after she went there. Nothing. Minimum punishment was 3 years and he has been given the maximum punishment for 5 years. Already he has undergone 4 years, almost 4 years.
Yes.
No, the prosecutor's failure is that while the victim stated that while she was coming from the place of incident, she met some persons, and that witnesses, the persons whom she met, they were not examined. Even the IO in his statement stated that the houses neighboring the victim's accused house, the persons who are the owners of this house, those witnesses are not taken into account. Their statements are not recorded. Only one witness, the Sagar Das, was examined. And moreover, on Kobita Das, whose name the victim is repeatedly saying, she was not also taken into consideration. She was not taken as witness, and statement was not recorded.
Yes.
And the witness of evidence of Lokhi Bora, the prime witness who sent the girl to the accused house, he has clearly stated in his cross-examination that the victim was accompanied by her brother. She was not alone. And even he stated that she was not crying, so she was not coming crying from the house of the accused. Only when the mother of the victim stated that something might have happened with the victim, then he came to know that something had happened. But what had happened, he did not know at all. Moreover, regarding the quantum of punishment, Lordship, the maximum punishment is 5 years, and a minimum is 3 years. He has been sentenced to maximum period of confinement, despite these discrepancies in the prosecution case. So already he has-
What is your submission on this thing?
This already
Quantum?
maximum punishment is 5 years,
Hmm.
and minimum is 3 years. And since some discrepancies is there in the prosecution case, so ought to have been given the minimum punishment. Already he has undergone almost 4 years of sentence. So the period undergone may be set off, and he may be released. He has got the maximum punishment. During trial, he was behind the bars for 5 months and 15 days. Thereafter, after judgment,
He was during trial,
5 months, 15 days.
5 months, 15 days
Yes.
during trial. And after conviction,
After conviction, it is stated in the clause list 3 years, 7 months, 13 days.
Hmm?
3 years, 7 months, 13 days.
3 years,
7 months, 13 days.
13 days.
Date of judgment was on 14/7/2022.
Hmm?
Date of judgment was on 14/7/2022.
Hmm.
Almost four years he have been behind the bar. So at least this
Maximum is 5 years.
maximum punishment is 5 years, and that was sentence by the trial court.
Hmm?
That was the sentence given to the accused petitioner,
Hmm.
appellant. My humble prayer at this stage is that since he has undergone more than almost 4 years, so he may be released. More than 4 years.
Yes, about 4 years, he is, I mean,
More than 4 years.
total more than 4 years. Mm. The maximum punishment is 5 years. Minimum is 3 years.
But in the case of Supreme Court whereby Mumbai High Court judgment was reversed, Attorney General for India versus Sotis.
Yeah, what about the case laws you are placing, please?
Only one case law regarding the quantum of punishment.
Mhm.
Here is also offenses under section 8 at page 579.
1 second. Yes,
Paragraph 50
Uh,
at
fif-
page 579.
para 50.
Offense is same under section 8. He is directed to undergo rigorous imprisonment for a period of
1
3 years.
second. Yes. Yes, read.
Accordingly, the accused Satish is hereby convicted for the offenses punishable under section of POCSO Act and under section 342, 354, and 363 IPC. He is directed to undergo rigorous imprisonment for a period of 3 years and to pay a fine of ₹500. And in default thereof, to suffer simple imprisonment for a period of 1 month for the offense under section 8 of POCSO Act. Since he has been sentenced for the major offense under section 8 of POCSO, no separate sentence is imposed upon him for the other offenses under IPC. Like our case.
In your case,
Also 354 was there.
so you have, so separate sentence was given
No,
out.
no, not given.
Oh,
Here
no.
also not given.
Oh, so no,
Here-
no. So
here
that's
also not-
fine. So
Then-
why are you relying on this?
Because in this case also,
Hmm?
3 years punishment was given.
That's a different thing. I mean, that's a, I mean, that finding, I mean, on the facts or whatever the, I mean, the nature of the, I mean, whatever, I mean, the incident, on the basis of that, 3 years was given. And in your case, 5 years has been given.
Here in this case, they entered into a house, they confined her into the house.
But that we cannot
That-
question now. I mean, that already been given.
Yes.
Now you can't say that like judge should not have given that at this stage. I mean,
Then if that, let's say already 4 years, more than 4 years, that may kindly be considered.
no, if you have some other cases.
No, I don't.
In this case, what was the fact?
There, 3 persons kidnapped one girl, confined into a room. They only 2 of them did committed the offense under section 10. This person was held responsible under section 8 only. This Sotis. They were convicted under section 10, but this person was sentenced for section 8 only. They confined the minor, committed the crime.
Anything else?
No.
Yes.
Lordship has produced the entire evidence, my lord, and as well as some portion of the judgment also, my lord. So I'll not burden the lordship, my lord, again reading all the, my lord, evidence. Now, my lord, the basic, my lord, appeal, my lord, basic ground of appeal in this case is that, as my learned friend has cited, my lord, non-examination of the, my lord, material witness. This is one of the ground, my lord. And secondly, my lord, the PW5, my lord,
Hmm.
who saw the victim, my lord, going to the house of the, my lord, accused person, my lord, along with the brother, that has only come in the cross-examination. My lord, before that, my lord, I just take your lordship, my lord, to the FIR, my lord. Just 2 lines in the FIR, my lord. Lordship has already read the FIR, my lord. Just 2 lines, my lord. Page number 13 of the my lord memo of appeal. Page number 13.
Hmm.
My lord, I am just reading the last 5 lines, my lord. ইয়াৰ পূৰ্বেও সি কেইবাদিনো তাইক বেয়া ইংগিত দিছিল বুলি আমাৰ আগত কৈছিল, যদিও আমি কথাটো পাতলকৈ ৰাখিছিলো ধেমালি কৰিছে বুলি ভাবি, কিন্তু আজি আমাৰ অজ্ঞাতে এতিয়া পুনৰ সেই ঘটনাৰ পুনৰাবৃত্তি ঘটাত উক্ত বিষয়ৰ সন্দৰ্ভত আমি আইনৰ কাষ চাপিবলৈ বাধ্য হৈছো। My lord, intention of the accused, my lord, was not good towards the victim government. My first humble submission. Because in the earlier occasion, my lord, accused has did some visit, my lord, which the PW1 says stated in her deposition, my lord. Now, my lord, the defense, my lord, they have failed to demolish the evidence of PW1, my lord, victim, my lord. Her evidence is consistent throughout the, my lord, entire, my lord, from the investigation itself, my lord. Because in her 164 statement also, what she has stated, my lord, that is important, as well as, my lord, in the evidence as a PW1, my lord. I'll just write few lines, my lord, from the deposition of PW1, my lord, page number 14, my lord. Because my lord, defense, my lord, they have failed to, my lord, demolish our evidence, my lord, in the entire, my lord, trial of the case. Page number 14, my lord, annexure 2, my lord. What's may come little middle portion down below, my lord.
Mhm.
I did not want to go, but at the same time, could not tell the reason to the mason that on earlier occasion also the accused used to come to our house and used to leave my wearing skirt. But what happened on that day, my lord? The PW5, my lord, he was working in their house, my lord.
Hmm.
Then he asked for a tagari, my lord. The tagari was in the house of the accused, my lord. Then the, my lord, PW5, he has asked this victim guard, my lord, to go and, my lord, bring the tagari. So when he went to the house of the accused, my lord, to bring the tagari, my lord, then he, my lord, done the committed the offense, my lord. Now, my lord, what has the PW5 has stated, my lord? What may kindly see? My learned friend has only rely on the evidence of cross-examination of the PW5, my lord. But in our examination in chief, my lord, page number 23, on the date of incident, when I was engaged in work, I was in need of tagari. That is corroborated by the PW1, my lord, victim, my lord. And the accused who was passing by at the time told me that the tagari was in his house. I then sent the daughter, my lord. He has not mentioned that, my lord, the victim has went to the house of the accused along with his brother, my lord. I then sent the daughter to Brozen to collect the tagari from the house of the accused. She accordingly went to the house of the accused but did not bring the tagari. After some time, I saw the victim inside their house and asked her about the tagari, but she did not reply anything. After about 1 hour, mother of the victim told me that something had happened with her daughter and that she had to return home crying. Mother of the victim told me that the accused had caught her daughter and so he returned home crying. Police interrogated me about the incident after the case was lost. Police also sent me to the court for recording statement under section 164 CRPC, my lord. That is, my lord, exhibited as exhibit 7, my lord, 164. That has been, my lord, this statement before the, my lord, judicial message that has been proved, my lord. Now in this cross-examination, they have brought, my lord, on the date of incident, the victim went with her younger brother to the house of the accused to bring tagari. I did not see the victim coming out from the house of the accused. The victim did not tell me about the incident. I did not see the victim crying. That is, yes, he has already, my lord, deposed in his, my lord, evidence in secret. Secondly, my lord, PW4, my lord. PW4 is the person, my lord, just after, my lord, coming from the house of the accused, my lord, he first met the, my lord, PW4, my lord. At about 9 a.m., I was, page number 21, my lord. At about 9 a.m., I was doing household work at the front side of my house. At that time, Astajita Gogoi came out from the residence and addressed me as a porta, and then she went to the residence of the accused Babul Das, my lord. PW4 specifically mentioned, my lord, that victim Asthajita Gogoi, my lord, while she went to bring the Tagari from the house of the accused, my lord, she addressed PW4 as a Borta, and then she went to the residence of accused Babuldas. That means, my lord, she went to the house of the accused alone. After about 3-4 minutes, I heard hue and cry of Asthajita from the house of Babuldas. While I reached in front of the house of the accused Babuldas, I saw Asthajita in the courtyard of Babuldas. She was crying. These are very important, my lord. When I asked her what happened, she told me that accused Babuldas had grabbed her breast. Police recorded my statement. In between my house and the house of the accused Babuldas, there is the house of my elder brother, Tularam Das. Now, my lord, cross. I have no good terms with Babuldas since quite some time. Front side of the house of Babuldas is visible from my house. Apart from the house of Babuldas, there are as many as 5 houses adjacent to another of my house. While Astajita went to the house of accused Babuldas crossing my house, at that time Milon and Kartik were also present along with me. It is not a fact that I did not state before the police that at the time of Astajita Gogoi came out from her residence and addressed me as a Borta, and then she went to the residence of accused Babuldas. It is not a fact that I did not state before the police that while I reached in front of the house of the accused Babuldas, I saw Porajita in the courtyard of Babuldas and that she was crying, and that I asked her what had happened. She told me that accused Babuldas had grabbed her breast. I have good terms with the informant Brozen Gogoi. Today I have come to the court with Brozen Gogoi. It is not a fact that I have deposed today as tortured to me by the informant Brozen Gogoi. It is not a fact that I have deposed falsely as per dictation of informant Brozen Gogoi against the accused, as I have not good terms with Babul Das, my lord. So they have failed to demolish this version of this witness also, my lord, that accused Babul Das has not committed anything, my lord, to the victim, my lord. Now, Lordship, whatever there, my lord, in 313, my lord, what is the reply, my lord, that I do not know, my lord, but this is not in the part of the, my lord, scan copy of the record, my lord. If Lordship allows me, my lord, then I'll just go to the 313
you
statement.
can take this.
My lord, in 313, entire 313 statement, my lord, first question was asked that PW1, Ms. Asajita Gogoi deposed in the court that her date of birth is 28/11/2006. Do you have anything to say? I am not aware about her date of birth. After that, my lord, PW1 Miss Asajita Gogoi deposed in the court that she knows the accused who is her father friend and used to address him as a Khura. Do you have anything to say? True. My lord, all the, my lord, questions put, my lord, only mentioned as a true, my lord. Miss Astajita Gogoi deposed in court that hesitantly she went to the house of the accused on the date of incident when she went to search of the Tagari, and after reaching their courtyard, she asked you to bring out the Tagari. Do you have anything to say? True. I told her to bring out the Tagari herself as I was getting late for market. PW1 Miss Astajita Gogoi deposed in the court that at first she refused to enter inside your house as no one else was present. Do you have anything to say? False. My two daughters were present at that time. They used to study together. But in their evidence as a DW1 and 2, they have deposed that they were playing while Astajita came to bring the Tagari. Thereafter, my lord, all the questions, my lord, true and false, my lord, he has stated. Then question number 18, my lord, PW1 Ms. Asajita Gogoi deposed in court that she raised hue and cry in front of your house in that Iniali. Do you have anything to say? She went out with the Tagari in her own house. Thereafter, I did not know what had happened. Itu কি লিখেছে বাবা? My younger brother also awake. Along with her name. My lord, only in my lord, question number 25, my lord, the question was put to him, my lord. Miss Astajita Gogoi deposed in court during cross that only when you told that you were busy in some works, she were inside your house, though she was not willing to go. Do you have anything to say? I asked her to take out the Tagari herself. Her younger brother also, along my lord, that word I have not been able to read, my lord. No, but we meant to say, my lord, her younger brother was also, my lord, with her, my lord.
Their defense is that younger brother was also there,
Also there, my lord. But
and Lokhibara also said so.
Lokibara also said, my lord. Lokibara, my lord, he says in the cross-examination, my lord, not in his chief, my lord. The cross-exam put by the accused, my lord.
But anyways, it's a fact which has come
Yes, my
out.
lord. So entire, my lord, 313 statement, my lord. Yes, my lord, expansion is only true and false.
See, there is no denial that the girl went there.
Yes.
There is one disputed fact is that whether the brother went or not.
Went or not. That is, there is
And
nothing.
and of course that incident is disputed.
Yes, my lord, yes.
And the one story is that the girl, in fact, she was pushed to the bedroom, towards the bedroom. Then she took the tagari, and like she hit him with the tagari
Yes.
on his back.
But when
Then
he
pushed him and came back.
When the accused pushed her in the bed, my lord.
Then
he hit
then
her-
she took the tagari and hit him.
Hit him, my lord, then my lord, she came out.
She came out. So, but that story, I mean, is it consistent story?
Yeah, this is consistent, my lord. That is why, my lord, I take your lordship, my lord, page number 49, my lord, the findings of the trial court, my lord.
49.
Page number 49, paragraph 31, my lord.
31, yes.
31, my lord, paragraph number 31.
Mhm.
Now, except PW5 Lokhi Bora, none of the other witnesses examined by prosecution deposed before the court that on the date of incident, the younger brother of the victim also accompanied her to the house of the accused to bring the tagari. That is much only mentioned in the cross, my lord.
But I mean, they did not consider this trial court did not consider DW and DW1
No,
and DW.
that is why, my lord, paragraph 31 I am reading, my lord.
Correct. Except this thing he says, no.
Yes.
But they also says that the girl was there. I mean, the boy was there.
The boy was there, my lord, that was initially put in the cross-examination of PW5, my lord.
No, that is fine.
My lord.
I mean, whatever way the factors come out, that boy was there. I mean, there was a statement.
Fine, fine.
I mean, we do not know whether it's
Fine.
true or false. And DW1 and DW2 also said that the boy along with the girl, they were playing in the courtyard.
As per the DW1 and 2, they said, my lord, boy and girl came to take the tagari and they were playing with them, my lord.
Correct. But that presence of boy was stated by them.
Yes, my lord.
I mean, there was a little bit of story here and there because they said ki like they came and like they came for the tagari, but like as a child do, I mean, they started playing there, and then their father said ki like I'm getting ready, they are delayed for the market. This thing.
So he
I mean, you take the tagari and go. That's what the statement is.
Now, para 31, my lord.
Mm.
Also, during cross-examination of the witnesses, defense did not take the plea that the younger brother of the victim also accompanied her to the house of the accused, or that the children of the accused along with the victim and her brother were playing together at the time of incident in front courtyard of the accused. Defense also during the cross of prosecution witnesses did not take the plea that on the date of incident, the victim returned from the house of the accused with the tagari as stated by DW1 and DW2 before the court. As per the evidence of DW1 and DW2, their father, that is the accused, took out the tagari from inside their house and handed over to the victim in front of their house, whereas the accused during his examination under section 313 CRPC stated that he told the victim to bring out the tagari herself and that the victim went out with the tagari to her own house. Thus, as reveals the plea of defense had not remained consistent during the trial, and the same accordingly creates doubt in their defense. But on the other hand, support the case of prosecution to the extent that on the date of incident, the victim went to the house of the accused to bring the tagari. That is why my lord, trial court has not accepted, my lord, the evidence of PW 1 and 2, my lord. Now, my lord, the final, my lord, what the findings of the trial court, my lord, page number 53, my lord. Page number 53, para 40, my lord. I find nothing in the record to doubt the testimony of victim, which is also corroborated by the other evidence on record. Prosecution has been successful in proving that on the date of incident at about 9 to 10 a.m., the victim went to the house of the accused being called by him to bring the tagari and on his residence. She went inside his house when the accused pushed her towards their bedroom and placed his hands over her breast and tried to open her sporting. She then assaulted the accused with a tagari and came out running. From the evidence on record, it can be further held that on earlier occasion also the accused tried to commit misdeed with the victim. As discussed, defense failed to prove that the accused was not guilty and had not committed the incident as alleged. Now, my lord, this is the findings of the trial court basically, my lord. Accordingly, my lord, he was convicted, my lord, for a sentence of, my lord, 5 years, my lord. My lord,
But what about this quantum of punishment?
Quantum of punishment is, my
And
lord,
he has already gone through more than 4 years.
4 years, my lord. That section 7, my lord, sexual assault, my lord.
Mm.
Whoever with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child touch the vagina, penis, anus, or
Those frame under section 354 IPC, read with section 4 of POCSO, that is assault or criminal force to a woman, and again on the penetrative sexual assault. Thereafter, after their